Before placing, my lord, the substantial question of law, my lord, the tribunal not passed a speaking order or rigid order and only copy paste the first appeal order. My lord, kindly have a glance to the page 11, para 7 to para 7.6. It is exactly the same, and the assessment order is first appeal order, my lord, at the page 23, para 6.3 to para 6.3.6, entirely extracted all the same paragraphs and without giving any finding. And there is another order of the tribunal of the assessee for the previous assessment year, where the tribunal already allowed in favor of the assessee without considering the matter, disposed of, and they copy paste the order of the first appellate authority without giving any reason, my lord. So let the matter may be decided by the first, give the reason.
No, but come to para 7.3.
My lord.
How can you say that?
7.3, my lord, that
this is an analysis of the facts.
That is analysis of CIT appeal, my lord. The same, my lord. In view of the above here, my lord.
No, is this a verbatim reproduction of CIT's order?
Yes, my lord.
Where do you get that?
My lord, 6.3.3. 25, page 25.
Okay.
Enter, my lord, up to 6.3.6 is the same, my lord. Without any change of word or sentence, my lord.
Oh, sorry.
Yes.
All right. All right. Admit the following question of law is framed for consideration. In view of the impugned order of the ITAT being a mere reproduction of the order of the CIT-A without any independent reasons given for concurrence, does the impugned judgment order required to be set aside and the matter remanded to the ITAT? Question mark. Paragraph. The present appeal by the SSC is directed against an order dated 28th March 2015, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, dismissing the assessee's appeal ITA 36/CTK/2014 for the assessment year, bracket AY 2008-9. Paragraph. The aforementioned appeal before the ITAT was against an order dated 20th November 2013 of the Commissioner of Income Tax Appeals, bracket CIT-A, Berhampur. To stop. Paragraph. Having heard learned counsel for the appellant SSC and the learned counsel for the department, the court notes that if the impugned order of the ITAT and the order of the CIT-A were to be kept side by side, it would become obvious that in the impugned order, the ITAT has simply reproduced the paragraphs of the CIT-A. We'll stop. One instance is para 7.3 of the impugned order of the ITAT, which is nothing but an exact reproduction of para 6.3.3 of the order of the CIT, bracket A, full stop. And it proceeds in the same pattern where till the penultimate paragraph of the impugned order of the ITAT, there's simply a reproduction of the orders of the paras of the CIT bracket A's order paragraph. It is obvious to the court, therefore, that the ITAT did not independently apply its mind while affirming the order of the CIT bracket A. Full stop. In other words, there are no reasons given by the ITAT for its conclusion. Paragraph. In that view of the matter, while answering the question in the affirmative in favor of the SSC and against the department, the court sets aside the impugned order of the ITAT and remands ITA number 36/CTK/2014 to the file of the ITAT for a fresh disposal in accordance with law on merits after hearing the parties. Paragraph. The aforementioned appeal will be listed now before the ITAT on 15th March 2023. The ITAT is requested to proceed to hear the appeal on merits and pass a fresh reasoned order after hearing the parties within a period of 6 months thereafter. The appeal is disposed of in the above terms.
Item number 2.
Kindly unmute.
My lordship, item 2 has been infructuous, my lordship.
All right. Dismiss as infructuous. All right.
Item number 3.
Has become infructuous.
Infructuous. Dismiss.
Item number 4.
Infructuous, my lord.
Infructuous. All right.
Item number 5.
My lord, my lord, my lord, item number 5, the entire demand has been based, your lordships, on the basis of retracted confessional statement, your lordship. And apart from that, my lords, the party, the opportunity of cross application has been not been extended to full extent, your lordships. And the parties are requested for a time measure only on the basis of only retracted.
Same appealable order, but
yes, my lord, it is appealable order, my lords. I'm not disputing, my lords.
yes, yes. You know that what
My lord, I pray for a small thing, my lords. This is with regard to on the basis of the investigation by the DGCI. This is not an independent investigation by the authority of sales tax, your lordships. And I have requested for the cross-examination of every person's, your lordships. Let the matter remand back to the adjudicating authority, your lordships, to adjudicate the matter in a fresh, your lordship. Because authority, if you remand back to the first appeal, it will not yield any result, my lord, your lordships. That's my only prayer, your lordships.
No, lordship. Your lordship, it is the second round litigation, your lordship. In the first round, no reasonable opportunity has been granted. Thereby, this honorable court has set aside the matter.
and send it back.
Yes, send it back to the assessing officer. And assessing officer, after giving the confrontation opportunity and everything in the order, your lordship, everything is there.
Right.
So duly pass the order.
Lordship, I will take a few seconds for my lord. You're not more than 2 minutes, your lordship. Lordship, can I glance to page 42, your lordships? I just reading out the relevant portion, your lordships. Page 2, second para, your lordships. On confrontation, it is contended that the contents of the report submitted by the Vigilance Division bias on information documents DGCI Raurkela and correctness of the allegation can only be established by the third-party confrontation. In view of the above contention, the representative dealer company requested to examine the evidence by confronting the parties dealer are available in the seized document alleged with whom understand. Since, my lord, since the parties dealer listed in the seized documents are huge in number, and it is not practicable on the part of the assessing officer to summon and confront those parties with the time limit. In view of such position, it was felt reasonable to issue summons to those 5 parties as listed by the dealer in the appellant dated 21st of January 2015 on due confrontation to accordance with the Provisions Act, Evidence Act for the sake of natural justice. Coming to the next para, your lordships. Accordingly, summon was issued to 5 dealers, namely Mr. Oro Ispat India Private Limited, Kuntuni, Mr. Rameswar Traders, Khandagiri, Bhubaneswar, Mrs. Khandagiri Traders, Khandagiri, Bhubaneswar, Mr. Steel Co, Mayapuri, Bhubaneswar, and Mrs. Shall I commence, my lord?
Just wait for a minute.
Yes, my lord. Again, same page 42, last para. In response to the summon, Mr. Steelco, the only dealer, appeared at the stage, contended in the presence of the accountant of the firm that the vigilance officer recorded the statement on coercion at the time, and he has not transaction either in with Mrs. Phoenix Steel Private Limited or Mrs. Jai Bhavani during the period from 1st April 2005 to 31st March 2007. Prior to that, he had only a single transaction for purchase of 8,100 kg of iron rod from rupees 1,85,574 by bill number so and so. The contention taken by the Steelco on this account is not convincing and appears to be afterthought and not acceptable as it contradicts the contention he had taken.
Mr. Dash, you're running a risk now. If you're inclined to confirm this, then you lose your appeal also. No right of appeal. So if you persist on arguing, we'll deal with this.
No, I'm not arguing better.
No. I'm saying you have every right to argue, sir. We cannot prevent you from arguing. But after arguing, when we start dictating the order, you don't say, now I want to go in appeal.
Never, I will, my lord. I promise.
Fine. Go ahead.
My only prayer, my lord, the whatever passage is acceptable, we, my lord.
No. You decide what you want to do, sir. You tell us.
My only
You say, sir, I want to argue this page 42, 43 in detail. You argue. We'll pass the order. When we pass the order, don't say, no, sir, I want to go in appeal.
My lord, my only prayer is to relegate me to the commission, to the assessing authority. That's the only prayer.
No. Then you argue the matter, sir. That's not a prayer.
Then I may be allowed to file the appeal with
Counsel for the petitioner seeks leave to withdraw the present petition with liberty to file an appeal against the impugned assessment order in accordance with law. If such appeal is filed not later than 1st March, accompanied by an application for condonation of delay explaining the delay on account of the pendency of the present petition, then it will be considered in accordance with law by the appellate authority. The court clarifies it is not expressed in view in the matter. The originals be returned subject to being substituted by attested photocopies thereof. All right.
Then I have a small prayer, my lord. I may extend it with further 4 weeks time because this is a closed unit, my lord. So I know to the financial difficulty will be difficult. That's my prayer, my lord.
3rd April. All right.
Grateful, my lord.
All right.
Grateful.
Item number 6.
May it please this honorable court. Appearing on behalf of the petitioner bank, challenging the assessment order at page 29, where they've held that the bank is a dealer under the provisions of the Odisha VAT Act, therefore liable to pay tax on the recovery of goods. There is a judgment of this honorable court deciding the issue.
The bank is not a dealer.
Bank is a dealer against me.
Oh, it's against you.
But it's been carried to appeal before the Supreme Court in SLP, where the Honorable Supreme Court has passed an order that no coercive action be taken against the bank in the meanwhile. Based on that, my lords have passed an interim order on 9/12/2016, where it stated the copy of the writ petition be served on learned standing counsel for commercial taxes in course of the day, who will obtain instruction in the matter and file counter affidavit.
It is still pending.
This is still pending, my lords. And on 20th March 2017, my lords have passed an order. Liberty is given to the interim order has been made absolute, and liberty is given to both the parties to move for listing of the matter after Honorable Supreme Court has rendered judgment.
Oh, I see. Since the SLP is stated to be still pending,
yes,
the occasion for listing the present case now does not arise in view of the order already passed by this court on 20th March 2017. Registry will abide by the said order. All right.
Obliged, ma'am.
Item number 7.
And may kindly permitted to withdraw.
All right. Member taken on record, dismisses withdraw.
Item number 8.
Item 8, my lord. State has filed counter. I'll
No, tell us what meant.
My lords, it has become infructuous also, my lords.
Ah,
I am for the intervener. So I am the licensee of the shop, my lords.
okay.
And they're challenging the specific public notification.
My lord,
And I have shifted the shop from that location to another location,
Oh,
which is at a distance of 9 kilometers.
I see.
And for that purpose, I am filing an affidavit.
I have challenged the entire process of issuing format.
He's already shifted his shops. 9 kilometers away is gone.
Yes, my lord.
no
So it's
question.
not going to impact the sales also. Affidavit is being filed, my lords.
My lord, my senior is today out of station. He has personal difficulties. I'll kindly taken up tomorrow.
What is there, sir? This shop is itself shifted.
And category of the shop
I
is
have-
that, my lords, it's a premium shop. That's a regular shop, my lords. So it's not going to impact any sales also, my lords.
Increase of shops without any demand, my lord.
There's no stay, sir. No stay granted. You say the present petition had been filed questioning the grant of license in favor of opposite party number.
I have challenged my lord the entire process of format notice.
Right.
Whether the grant of a shop by the government is right or wrong in view of the rule 29, my lord.
The present petition had been filed questioning the issuance of a notice, public notice in Form 8 on 26 April 2002 and Form A sale notice dated 9 July 2022 in respect of a BMC premium foreign liquor off shop number 6 paragraph. Till date, no notice has been issued in the present petition. Full stop. In the meanwhile, the successful bidder in whose favor the license for the aforementioned on shop was finally issued has filed IA number 11374 of 2022 seeking impleadment in the petition. Full stop. The said intervener, that is the Mohit. Who's the intervener?
My lords, Mohit is the licensee, my lords.
Mohit, the licensee, has today filed a further affidavit stating inter alia, no, through his attorney, power of attorney holder, that the shop itself has been shifted from ward numbers 58 and 59 of BMC to plot number 479/2805. Igina, which is a distance of 10 kilometers from the shop of the present petitioner. So, paragraph, in view of the above development, it appears that the cause of action for the petitioner to approach this court in the first instance does not survive. Full stop. The petition is accordingly disposed of.
My lord, liberty may be granted. I will challenge his license, my
Not
lord.
necessary. Yes.
Item 9.
Grateful.
Item 9, my lord, kindly taken up tomorrow, my lord. My senior is today out of station, my lord.
This is the government's order rejecting the proposal. If your lordship can say, I will file counter to this. The proposal for grant of on-shop was rejected by the government. The final order of the government is under challenge.
The notice, he accepts notice, reply within 8 weeks, rejoined for the next date. Sixth July.
My lord, may I pray, my lord, before March, my lord, it will become infructuous after 31st of March, my lord.
Why even now it's late, sir, then? Which means that man has already, whoever has got it has already got it for some time now.
No, his application has been rejected.
No, somebody else has got it or no?
No.
Okay. That can be reconsidered if your lordship will direct that the same application will, if your lordship will allow the writ petition and his application can be, same application can be reconsidered. There is no
15th March.
Item number 10, item number 10,
None appears dismissed.
item 11,
My lords, no instruction.
No instructions.
item number 12,
12, 13 and 14 will not have instructions to appear. Subject to your lordship's kind consideration. Your lordship can grant me some time to remove the defects. There are a host of defects, my lord. As per the SR done on
All right.
10th of January 23, my lords.
List on 16th February, defects be removed in the meeting.
My lords.
I am appealing on order.
I've served extra copies. My lord. That'll cover
12, 13 and 14.
12, 13 and 14 also.
Correct.
Obliged.
Item number 15,
May I please, your lordship? The appellant challenging the order passed by the honorable single judge. Honorable single judge allowing the writ petition and setting aside the order passed by the revisional court. The only short point involved in the case, your lordship, that the present opposite party relies upon a judgment of this honorable court, full bench judgment. The honorable single judge has refuted to see it as because it is a criminal case. But fact remains, it is a consolidation act and full bench judgment of this honorable court. And only short question involved in this case, whether after publication of section 4.4 of the notification under Orissa Consolidation and Holding Prevention of Family Prevention of Fragments of Land Act, whether the preliminary decree suit for partition will be abated due to the area coming under the notification. That is short point involved in this case. The honorable single judge has set aside that only on the ground that this judgment is not related to criminal case. No, yeah.
All right, to simply say notice, he accepts notice on behalf of opposite party number
State, your lordship, that is 9, 10
10 and
and
11.
11.
Notice to the remaining respondents, trustee in addition. List on 11th May.
Obliged.
item number 16,
My lord, defect has been removed. And question has been framed in page 13, my lord. Page 13, page 12 and 13. Whether in the facts and circumstances of the case and in law, the honorable IT is correct in allowing the commission expenses rupees 3 crores 92 lakhs 80,961 when letter issued to many of the commission agents whose names were furnished by the SSC were either written, answered or not responded. Whether in the facts and circumstances of the case and in law, the honorable IT is correct in allowing the commission expenses through the buyers through the agent, Scan Still Limited and others have categories denied involvement of any agent in the transaction of purchase sale with the SSA. Question 3. Whether in the facts and circumstances case in law, the honorable IT is correct in relating the addition of which 1,38,66,243 under section 14A when the SSA is exempt income during the year. Then D. Whether in the facts and circumstances case in law, the honorable IT is correct in relating the addition holding that satisfaction is not recorded by AO when the SSA
All
is
right, it's a notice returnable. 12th May. No, sorry, 11th May.
well, same is ITA 4. It is not in the list. Same assessment here.
So this is holds good for 16, 17? 16 and 17 or only?
4 of 2021.
No, 5 and 7. It
Yes.
applies to both.
Yes, yes.
All right.
12, 13 and 13, 14.
item 16 and 17.
Then same the question framed.
Assessment years.
Assessment two assessment year is 13. It is 14, 15.
Not connected, I think.
First page.
ITF 5 is ITF 5. That is assessment year 13, 14. Correct.
12, 13.
It is 1213 for ITA 4 of 2021.
You tell the numbers, please.
Number 389 and 390 CTK 2017.
ITA number 5 of 2001, which just now you have placed, that
Yes.
relates to assessment year 13-14. Correct?
Yes.
Then
4.
ITA
4
of
4 is not on board.
Not on board.
That is, what is the assessment year for that?
2012 and 13.
Previous year.
Assessment year.
Can we write? Take on board that 4. Yes, special notice take on board. Notice returnable. Anyone appearing for the SSC? No. All right. Notice returnable 16th May. Both the cases.
Item number 18.
Item 17.
Same order, sir.
Same. One. It is also same. 6 and 7.
Yes.
It is 7 by items. Item 6 also there. 6
All
of
right,
2.
we've taken on board that.
Okay.
4, 5, 6, 7.
Item number 18.
May please the Lordship, this is proceeding under section 263 of the IT Act. The so-called notice issued holding the income is erroneous and prejudicial to the interest of revenue at Annexure 3, page 14. Only hardly time was given 10 days, but the petition filed by the appellant stating, petition here, Annexure 4, page 18, requesting that the allow reasonable opportunity to produce any other material to establish genuineness of income earned, for which your kindness petition will favor. So no opportunity is given to produce the details, etc., which your Lordship has already held in the Tekram case in New Delhi High Court. Relying the case of Amitabh Bachchan, opportunity must be given.
All right, notice, you just say notice,
Yes,
yes, notice. But against this assessment order, an appeal is preferable.
This is 263.
You go to 263. I'll go to tribunal.
So counsel the petitioner seeks leave to withdraw the present
Relying
petition,
the-
but she approached the tribunal.
It is against the tribunal order. Tribunal also has not given opportunity because of the pandemic, and the COVID pandemic also are not able to allow. So let the matter be sent back to tribunal, your Lordship, so that I can place all the materials there, which your Lordship has been.
No, but your appearance is shown in the impugned order.
After hearing both sides.
After hearing both sides. The impugned order was not in your absence.
Not absent, so the opportunity is going to produce detail.
Then it will be irregular. Just say notice returnable. Then we don't send you back. 9th May. Mr. Chimanka accepts notice. Copy the paperwork we served on him. Forthwith.
Item number 19.
Right, please, my lords, I appear for the respondent.
Yes.
Has not been admitted.
Yes, yes.
Lordship, here the issue involved is not whether complete material were not produced and not available in the assistant officer at the time of original assessment, and thereafter the reassessment procedure is initiated under section 147 of the IT Act. The tribunal held, my lord, that this material was always with the assessing authority.
Correct.
No, my lord, here Lordship kindly, I am relying on the judgment of the Gujarat recently, my lord. There the Lordship held, if your Lordship see the paragraph 20. Here, my lord, the expenses or other expenses not been detailing, my lord, has been produced. If your Lordship see, your Lordship pays paragraph 20, kindly have a glance, my lord. Page, internal page 22, paragraph 20. The assessing officer required jurisdiction to reopen assessment under 147. Read with 140 that where the information must be specific and reliable. As held by the Apex Court in case of Phulchand Bajranglal, since the belief is that of the ITO, the sufficient reason for forming the belief is not for the court to judge, but it is open to assess to establish that there exists no belief or that the belief is not at all bona fide one and based on vague, irrelevant and non-specific information. To that limited
Yes, please.
Yes. To limited extent, the court may take a view taken by the ITO and can examine whether any material available on record from which the requisite relief could be found by the assessing officer and whether that material has any rational connection or have a live link with the formation of the requisite relief. It is also immaterial that at the time of making original assessment, the assessing officer could have found by further inquiry investigators whether the transaction was genuine or not. If one of the basic subsequent valid information, the assessor form a reason to believe on specifying when condition prescribed under 147 Act that no full and true disclosure fact was made by the assessor at the time of original assessment, and therefore the income chargeable tax had escaped assessment as belief, and the notice of reassessment based on such belief opinion need no interference, Lord. Therefore, in the present fact, Lord, if you Lordship see the page 33 of the order of the tribunal, Lord. It is admitted fact, Lord, that the expenses has been incurred with the foreign currency under head of other has not been properly expensed. Therefore, Lord, the reassessment procedure initiated based on the what qualifies the amount for foreign exchange and what is the amount which is allowed by the assessment at the time of original assessment. The true picture has not been placed by the assessee at the time of original assessment. Therefore, my considered view, Lord, that he has not produced all this relevant, not produced the document at the time of original assessment, and thereafter, Lord, this issue has been reason to believe that there is a escape assessment. Therefore, Lord, reassessment procedure has been initiated, Lord. And I will on the page paragraph 20 of this judgment, and therefore I request Lord, kindly form the question of law for answering by this.
But please, my lords, this issue has already been, if my lords will first see the tribunal's order para 20.
Yes.
My lords, that's a finding of fact which has not been traversed as being perverse before, my lords. Considering the facts and circumstances of the case, may I read, my lords? Para 20.
Yes.
We are of the opinion there is nothing to suggest that all primary facts were not disclosed by the assessee at the time of original assessment, nor any failure on the part of the assessee to disclose fully and truly material facts has been ascribed in the circumstances narrated before us. It cannot be said that the assessee suppressed any facts. Thus, we are of the considered opinion CIT appeal in operative para 2.2 was right in holding that apart from the assessment order, it was found that the AO, after considering the reply of the assessee, had made a disallowance of 194.85 crores, which does not include expenses in foreign currency and others, and passed an order under 140, dated under 143.3. There was no new tangible material as is discernible from the reasons recorded by him for initiating reassessment proceeding in his hand. Thus, it's a case of change of opinion. It is a case that if a notice under 148 has been issued without the jurisdictional foundation under 147, new tangible material which was not with him during original proceeding being available, then notice and subsequent proceedings will be without jurisdiction and liable to be struck down. In view thereof, we have no hesitation in affirming the findings. Because my learned friend, Mr. Jena, who's assisting me in this, he's also there. This issue also came about for in the assessee's own case for assessment year 8-9. He's just handing over a copy of those orders. And we'll see.
Para 3, Your Lordship.
Para 3, on perusal of the impugned judgment, of the order of the ITAT reveals that in the original assessment proceeding, assessee had produced various documents, books of account on which assessment order was passed under 143.3 as noted in para 4. The assessee submitted copies of audited balance sheet returned on TDS on commission paid, TDS details, traveling expenses, and so on. Further, in respect of disallowance under 43B and made a disclosure at point so and so. This persuaded the ITAT in para 17 that reasons recorded from the reopening of the assessment made no reference to any fresh tangible information in which came to the notice of the AO after completion of the original assessment. A reference was made to Kelvinator. I'll skip that. Para 4 is the finding. Having heard counsel for the parties and having carefully perused the impugned order, Court is satisfied. The question framed has to be answered in the affirmative in favor of the assessor and department. Indeed, there appears to be no fresh material on the basis of which AO could have formed the reason to believe that income has escaped assessment. And my lords, accordingly, the appeals was dismissed. May I, my lords, for completeness, also show the reassessment order?
Yes.
And my lords, we'll just see page 2 of the reassessment, page 1 first and then page 2 of the reassessment order. There is an admission that the AO has himself relooked at the accounts and initiated 148. Kindly see, my lords. Para 2 first. Because para 1 records that an assessment under 143.3 was done. Para 2 says, thereafter from the PNL of the assessee, profit and loss of the assessee, it is observed that it revealed that assessee had made expenses of so and so. And my lords, the schedule of balance sheet is referred. These are part of the original assessment. In course of scrutiny assessment, the assessee submitted amount was actually 8.5 instead of 3.9. So, my lords, I clarified this amount also in the original assessment. The mistake was due to typographical error. Out of this, so-and-so was paid in foreign currency. This is all explained under 143.3 assessment. Now, kindly see, my lords, para 2, just above para 3, it's an unnumbered para. However, it is noticed from the record that the assessee had not filed any application for lesser deduction under 195.2. My lords, so therefore, the starting point of the reassessment is my record. There is no fresh tangible material today.
Yes. Yes, Mr. Satri.
Lord, your lordship, that 3 lines below that paragraph, the assessee had failed to deduct TDS and also failed to obtain no deduction certificate from the concerned ITO.
This was there originally also, sir. What is the new tangible material?
But the PL account schedule O has not been clarified. The schedule O, where there is a
bifurcation. One thing, dealing with it is another. If it is already available, then the question of reopening doesn't arise.
It is available, but the availability schedule O.
So there's case law to say there's no need to tell him how he should read the document and what opinion should form. Yes, yes.
This bifurcation in the schedule O, which has been filed by the petitioner, this issue has not been dealt with at the time of original assessment.
No, question is it's present. The material is present. There's no new tangible material now.
No, that is
the I'm sorry.
Correct, Lord. I absolutely bow down, Lord. It's correct, Lord. There is no new tangible material.
Correct.
But the fact remains, Lord, this material has not been considered at the time of assessment. Therefore, Lord, relying the judgment of this Gujarat High Court, wishing on the.
Malords, factually, may I clarify, Malords, that statement, it was not considered, is also wrong. Malords, will see para 2 once more with me of the assessment order. Para 2 of the assessment order, which Malords, yes. Malords, I was reading. Kindly see the third line, Malords, last 3 words. In course of scrutiny assessment, 143.3, the assessee submitted the amount was actually 8.59 crore instead of 3.5. I gave explanation. I said there is a typographical error. I explained this in the original assessment. Therefore, the statement that this was not considered is also wrong. That's.
All right. Admit the following question is framed for consideration. No, admit the present appeal by the revenue is directed against an order dated 9th September 2020 passed by the IT-80. Cuttack bench, Cuttack bracket, IT-80. In IT, dismissing the revenues appeal, IT number 399/CTK/2018 for the assessment year 2011-12. Paragraph, the question that the revenue raises to urges the court to examine is whether the IT-80 was justified in rejecting the plea of the revenue that the reassessment order for the AY 2011-12 could not be said to be vitiated on account of absence of any new tangible material to justify the reopening of assessment. Paragraph, the original assessment took place for the AY in question, that is 2011-12, as a scrutiny assessment under section 143(3) of the Income Tax Act 1961 (Act). The assessing officer (AO) in the first instance passed the assessment order dated 14 March 2014, determining a total income of approximately rupees 409 crores. In appeal, this was revised by the order dated 7th November 2014 of the CIT bracket A to rupees 209, 26, 24, 384. Paragraph. The AO subsequently observed that the SSC had showed expense of rupees 3.59 crores in foreign currency towards single quotes others, unquote, and that tax was required to be deducted under section 195 bracket 1 of the Act from payments of rupees 8.08 crores made by the SSC. To stop further, the SSC had not filed any application for non-deduction or lesser deduction of tax under section 195 bracket 2 of the Act. Full stop. On this basis, the AO opined that a sum of rupees 8.08 crores was required to be added to the total income of the SSC under section 40 bracket small a bracket small I of the Act. Paragraph. This led to the notice under section 148 of the Act being issued to the SSC. Full stop. The reassessment was completed under section 143 bracket 3 oblique 147 of the Act on 30/12/2016, determining the total income at 217,3715,780, disallowing the expense of rupees 807,91391 under section 40 bracket A bracket I of the Act. But in this round of proceedings, the question really was whether the reopening of the assessment was, in the above circumstances, justified. Paragraph. The CIT A agreed with the SSC that there was no new tangible material to justify the reopening of the assessment, and that it was based merely on change of opinion. To stop, it was this order of the CIT A which was upheld by the ITAT by dismissing the review's appeal. Paragraph. Mr. Sachin Jolly, learned counsel appearing for the SSC on advance notice, has placed before the court the judgment of this court dated 14 March 2022 in ITA 31 of 2018 bracket Principal Commissioner of Income Tax versus Indian Metals and Ferroalloys Limited, Rasulgarh, Bhubaneswar, where for the AY 2008-09 against a similar order, this court dismissed the revenues appeal, referring to the judgment of the Supreme Court of India in CIT versus Kelvinator of India Limited, 320 ITR 561, bracket SC. On the other hand, Mr. Satpathy Leonard, senior standing counsel in the department, sought to place reliance on the decision of the Gujarat High Court in Yogendra Kumar Gupta versus ITO, MA Indu oblique GJ oblique 1345 oblique 2014, stating that even though the books of account may have been produced at the time of the original assessment, it would still be open to the AO to reopen the assessment if it was felt that any taxable sum had escaped assessment. Paragraph. The facts of that case reveal that the unsecured loan obtained from a creditor for the material supplied by them was a result of single court's accommodation entry in the forms of loans and advances, unquote. And in those circumstances, it was held that it could not be said that there is no new valid and tangible information leading to the reopening of the assessment paragraph. However, in the present case, the admitted position is that there was in fact no new tangible material. We'll stop by looking at the same books of account. The AO has come to the conclusion regarding escapement of taxable income. Paragraph. In the considered view of the court, the dictum of the Supreme Court of India in CIT versus Kilminator of India Limited, bracket Supra, would squarely apply in the facts of the present case. Consequently, concurring with the view taken by the CITA and the ITAT, this court declines to frame the questions urged by the revenue. The appeal is dismissed.
I'm grateful, Milord.
Item number 20.
The office note has been perused. The correction be carried out and the order be reissued.
Item 21.
My lords, there is delay of 20 days. My lords, here in this case, kindly see the assessment order, my lords, at page 13. It was antedated, my lords. The period limitation expires on 31/3/2016, my lords. My lords, kindly see the date. It was overwritten. And my lords, the memo was issued 2 months after, and it was served on me after 7 months, my lords.
The original record has to be called for.
Your lords, copy also.
Oh, yes, my lords.
You say notice, he accepts notice, copies the petition be served on him. The original record of assessment be produced on the next date. List on 24th April.
Item 22.
My lords, in item 22, against the impugned order, your lordships, state is to file a revision petition, your lordships, while it's issuing notice, your lordship, on 25th of January 2023, your lordship. On my request, your lordship, this matter, today's matter already been listed for hearing on 19th of April, your lordship.
All right, list on 19th April, along with STREV.
Mine had already been listed, your lord.
No, along with the states.
States.
25/21, your lordships.
Along with STREV 25 of 2021. Okay.
Item number 23.
May I please, your lordship? Here, your lordship, the question of law is at page 34. Your lordship has already decided this issue. And against your lordship's decision in Cobra installation, your lordship might have remembered that Cobra installation, so far as the limitation of 40-6 and approval of the commissioner, your lordship. Against, and your lordship cognizing the strands, your lordship, honorable, your lordship, against that order, the department has gone to honorable Supreme Court. And in the meantime, honorable Supreme Court has referred the matter to the larger bench, your lordship. Your lordship, in the meantime, the matter has been referred to larger bench to decide. Mute here. What's the next one? What I pray your lordship may admit this revision and question of law may be framed and let it be finite till.
No, is there a stay of Cobra installations?
No, lordship, no stay, but that matter has been referred to larger bench, your
I
lordship.
know. Yeah, it is seen that by the order dated 11 July 2022 of the Supreme Court in SLP Civil Diary number 29294 of 2018, bracket Commissioner of Sales Tax Odisha versus Mrs. SL Mining and Industries Limited, bracket. The issue arising in the present case, which also arose in the above case, has been referred to a larger bench of the Supreme Court of India. Paragraph that view of matter while adjourning the petition signed by awaiting the judgment of the Supreme Court in the above matter. Liberty is granted to the counsel for the department to mention for listing after disposal of this above case by the Supreme Court.
Lordship may. Your lordship may stay the order of the. Your lordship, order of the Law and Tribunal. Your lordship, what happened in this case? Your lordship, the first appellate authority has set aside the matter for face assessment. Against that, tribunal has confirmed the assessment, deleted the assessment as well as first appellate.
It will all abide the.
Your lordship, exactly.
No need for stay.
Your lordship, item number 27 is the same.
All right, same order in place.
Item 24.
24 and 25 are the same matter.
Yes.
Your lordship, there is a delay, but actually there is no delay. Your lordship will find that the matter was going on. What was it? Going on before this honorable court, your lordship kindly look to my notes.
What's the delay?
In,
731.
Notes filed on today, your lordship, para 40, your lordship had allowed me to withdraw this writ petition and file the revision. And the revision has to be filed by, granted the leave, file the revision not later than 1st November 2021. And I have filed this on 25/10/2021. And then the matter was going on before this honorable court, even before 2004, the second appeal of the tribunal, because I had come here before in a writ petition.
All right.
Now, your lordship, this judgment, this matter is covered by your lordship judgment. Here in this case.
Oh, same as Vadilal Chemicals.
Vadilal, I have given the copy of the judgments.
All right. Anyway, notice has to go, sir. Notice, he accepts notice, both on the delay as well as the main petition. Returnable.
Delay would not be because there is no delay.
Let him anyway file a reply, sir. No problem. Returnable. 2nd May.
It will come up on 2nd May or?
Yes, 2nd May.
Great.
Item 25.
Same thing.
Same. 25 is the same.
Another year.
Item number 26.
May please the lawsuits. Item 26 lawsuits kindly see page 17 of the assessment order. It is an order passed under section 43 of the OVAT Act, Malos.
Yes.
And it is lawsuits. There is no opportunity. Order 39 passed, no intimation is given to a lawsuits covered by a lawsuit judgment. Case of automobiles, my lords. Case of automobiles.
I was appearing.
Do you have any objection?
Let's see, only objection is
covered.
No question of law has been raised. Only that is, but in the prima facie, in the assessment order itself, says only the self-assessment 39 was completed earlier. So that is the
No communication.
No service. Your losses. Obliges.
In view of the judgment. Okay, you say admit the following question is framed for consideration. Whether in view of the judgment of this court in Keshav Automobiles State of Orissa, bracket judgment dated 1st December 2021 and STRV 64 of 2016. The impugn order of the tribunal and the corresponding orders of the first appellate authority and the assessment officer, assessing authority required to be set aside. Question mark. Paragraph, having heard learned counsel of the parties, it is obvious that the initial self-assessment order was not, acceptance of the self-assessment order was not communicated. Acceptance of the return filed by way of self-assessment was not communicated to the petitioner SSC by the department. In that view of the matter, in view of the judgment of this court in Keshav Automobiles, which has been affirmed by the Supreme Court in Rathi Steels, the question is answered in the affirmative, that is in favor of the SSC and against the department. Consequently, the impugn order of the tribunal and the corresponding orders are set aside.
Mr. Mishra, another case recently after Keshav Automobiles,
Your Lordship,
particularly this communication on that finding was given and STRE was dismissed. Do you have that reference? Particularly on
Your Lordship,
communication.
Your Lordship, I have argued. Your Lordship, I'll find out the order.
This type of observation was there.
Your Lordship,
39 was earlier completed.
Your Lordship.
But Lordship
in fact, you said you left out that point and you asked.
Your Lordship, I have argued and I have given the detail. Your Lordship, I'll
to this Keshav Automobiles.
Your Lordship. On many occasions, many aspects, I have tried to all my level best, Your Lordship. And Your Lordship, also, I have not mentioned, Your Lordship, I don't want to irritate Your Lordship.
No.
In the, particularly in against that SLP order, Rathi Steel, so far as the Rathi Steel, already review petitions have been filed. But since no stay, no admission, so I...
Correct.
Your Lordship,
see, you have to keep trying, sir.
Your Lordship.
You should never stop trying.
Your Lordship.
There are benches and benches which always have a different point of view. So.
Your Lordship.
Item 28.
The order number 47 dated 21st September. My lord may kindly see. So pursuant to that order, no affidavit has been filed by them.
Lordship,
Date was supposed to.
21st September, Lordship directed me to take instruction. My lord, I'll call with a definite instruction. Your Lordship may call this matter next week. I have talked with the secretary who will furnish the instruction. Your Lordship may call this matter next week.
At the request of Mr. Kuntia, Learned Counsel of the government, list on 22nd February.
Item 29.
My lord, I am now challenging inaction of the OP number 3, my lord, who is not initiating land encroachment proceeding, my lord, against OP number 4 to 11. They are encroaching government land, though they were also awarded compensation and their land was acquired for the road. And they have also awarded the compensation for that purpose since to 1983.
See this annexure 2,
my lord,
shows proof of delivery of this annexure 2.
My lord, I have taken averment, but I have not.
Then you have to file a fresh representation.
My lord,
the petitioner seeks leave to withdraw the presentation, with liberty to file a fresh representation with the authorities, and after following up with such representation, to seek appropriate remedies for its performance. This post office withdrawn, liberty is made.
Item number 30.
May please, my lord. 30 and 31, my lords, are identical matter, my lord. This, I am for the petitioner, my lord. This is a GST matter where the challenge is to the order of the additional commissioner appeal. The issue relates to rate of GST on royalty for the period September 18 to December 18.
No, this is against the first appeal order.
First appeal order.
You have paid 10%.
We have paid 10%. We have paid, in fact, we have paid 30% also, my lord. My lord, there is an identical matter which has already been admitted, my lord, with interim protection. I crave leave. My lord, my local advocate will submit the copies of this order,
Yes,
my lord.
yes. Mr. Satpathy was appearing on that date.
Your Lordship, it is
5%, 18%.
Your Lordship, it is those matter in Kalinga Iron, also Arbind Steel, Your Lordship.
Correct.
Your Lordship, all these matters have been fixed. Your Lordship has fixed on 21st
August, my lord.
All right. Notice returnable 21st August. Reply be filed within 8 weeks. Rejoined for the next date. Counsel, the petitioner points out that the petitioner here has paid already 30% of the demanded tax during the stage of first appeal. That view of the matter, no further coercive steps shall be taken against the petitioner during the pendency of the present petition. List along with writ petition civil 5278 of 2022 on the aforementioned date.
In both the cases, I am appearing for opposite part number 2 and 3.
All right.
Item number 32.
32 and 33, my lord, one pass over.
Pass over.
Item number 34.
Please, my lord. My lords, on the last occasion, we were directed to file the requisites with regarding to impletion of the IIC, my lords. We were under the impression that the IIC would generally appears through the state, so we have served an extra copy, my lords. I'm deeply apologetic. We'll file the due requisites and serve another extra copy on statements.
Impletion application is to be allowed and IIC is to be implemented as opposite part number 5. Then only I can take the notice.
Right. At the request of counsel, the petitioner who needs more time to file the process fee for service of notice on the IIC Commando Police Station. List on. Second May.
Item number 35.
May I please, your lordship. But your petitioner is a licensee in respect of a on-shop, my lord. Earlier, his shipping application was rejected by the collector. He approached this honorable court, and this honorable court by Annexure 6, page 21. The operating portion is, my lord, 26. While setting aside the order of the learned collector, the matter was remitted back fresh consideration, taking into the judgment of this honorable court that matter has been decided in Khemari Samal, my lord. Thereafter, my lord, lordship will find Annexure 9, there is public notice for shipping. That has never been given effect. Again, another 5 months, Annexure 11, another shipping public notice was there. This public notice is still on, my lord. It has never attained finality, my lord. Then, my lord, the number of occasions I have approached the different authorities. Finally, lordship will find the Annexure 15, page 42. The Land Excise Commissioner directed collector to complete the process of shifting and recommended the file to his office so that the shifting can be effected, my lord. That has been not yet done. During penance of this shifting process, now Annexure 18, my lord, there is a demand notice where they have claimed for due to shortfall of the MGQ, they have claimed, my lord. Because already the premises last 1 year I have vacated because I was constrained to vacate because the tenant had solved. It should be noticed. Sir, you go to the commissioner now.
Yes, better, my lord.
Till that period, I may be protected. All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file an appeal before the commissioner.
Yes, my lord.
Central excise against the impugned demand dated 8th August 2022.
My lord, state excise.
State excise, my lord. Oh, okay. That is Secretary Department.
No, that is Excise Commissioner.
Excise Commissioner.
That's what. That's what I said. Excise Commissioner.
State excise.
OP number 2.
Bracket OP number 2. If such appeal is filed not later than 1st March 2022-23, accompanied by an application for delay, explain the delay on account of the pendency of the present petition, be considered in accordance with law by the appellate authority. The appellate authority will, after hearing the petition, pass an appropriate order within a period of 4 months thereafter. Till such time, no coercive steps shall be taken against the petition.
Matter difficulties, my lord, the excise office was very much available
just nearer to High Court. It has shifted to Bhubaneswar.
No. It is also running here.
No.
It is also
Yesterday,
running
day
here.
before yesterday, I had been to there for some work, but nobody is there.
That is a different matter. But office is never shifted. The excise commissioner address is Cuttack.
No, ask him to go in hybrid mode. Yes, that would
He
be,
is
yes,
in
my lord.
hybrid mode. He is always in hybrid mode.
Oh, I see.
No,
That would be better for us, my lord, because lordship, no, here we are there. Correct. He says he's in hybrid mode. So
Yes,
ask
in
for
hybrid.
online hearing.
Yes.
Oblige.
Through WhatsApp and
Correct.
he knows.
Item number 36.
None appears dismissed.
Item 37.
May it please your worship. Item 37, that the impugned judgment mirrors my client's matter, lead matter. Now, Mr. Mishra, let him start the argument. I will join with him.
This will take some time, sir.
Yes.
I will take it at the end of the board, man. End of the board.
Okay.
Well, I had a small prayer. I am appeared there about 20 matters. I missed some of the files of 2005. I could not get it. I prepared a date chart only for one first item. If I accommodate from 1 week, I collected the files from my friends.
Why postpone everything, sir? Everything else is 2016 matter.
Yes. 2005 matters are there.
It's a matter of 97.
Only for I could not find the trace of the file 2005. Only 1 week time. Only calling my friends.
97.
1 week just only to collect my brief from my friends. 2005 there are 5, 6 petitions. If my lord kindly permit.
Then it will go up to after vacation, sir.
My lord.
Counsel for the Provident Fund Commissioner, Mr. Patnaik, Senior Counsel for the Provident Fund Commissioner, needs time to collect the paper books in some of the matters and prepare the arguments at his request list of 11 July.
Man, grateful.
Interim orders to
My friend may not be willing to argue. I believe. No. These are the matters. In fact, we have paid the amount and tribunal by a region order has disposed of the matter, milords. And as per section 7L4,
Do you have doubt on my
absolutely.
on my spelling falsehood?
No. But we could have asked for, we could have given copies. My friend is always there.
I collected.
Unnecessarily 6 months is not a small time.
Can it be a little earlier, Your Lordship?
And yesterday night minutes, I spent the entire time for this brief minutes. If my friend would have told me, I could have handed over copy at his residence. I don't mind at all. No.
Can it be a little earlier, Your Lordship?
Only that is why I pray minutes. It's a very small thing. It will not take even more than 1.5 hour time.
But still, sir, it's a huge batch. So let's audit.
Item 38. Item number 38.
None appears dismissed.
Item number 39.
Steps for limitation.
None appears dismissed.
Item number 40.
Same one.
Item 41.
Memo taken on record. No instructions. Withdrawn as not pressed.
Item number 42.
May. Page 40. Certified case. In some cases, Your Lordship has fixed it 8th May.
All right. List on 8th May along with
Batch of read petitions have been fixed.
Anyone.
And in other cases, Your Lordship is disposing that it has been disposed of the first at the admission stage.
No, here service is complete.
Yes, no copy. It has come first time.
No. Here I think it's come earlier.
And someone has appeared in. Okay. Someone has appeared, his name appears.
Correct. Somebody's appeared. No, but last reports is AD not back. Item delivery confirmed, right? All right. He said, despite service of notice, none appears on behalf of respondent. Number 1, 2, and 3. 1 and 2, you say. Paragraph. It is seen from the impugned order that the writ petition of respondent 1 was allowed on the very first date. No, disposed of on the very first date without any opportunity to the appellant to file any reply on merits. On that short ground, the impugned order is set aside and writ petition civil 21337 of 2019 is restored to the file of the roster bench below on single judge, where it will be listed on April 2022. The present appellant will file its para with reply to the writ petition positively on or before 27th March 2023. And no further time will be granted for that purpose. Full stop. The writ petitioners would file the rejoinder before the next date, that is 10th April 2023. The learned single judge is requested to proceed with the hearing on merits and dispose of the writ petition as expeditiously as possible. That's it.
Hmm. 77 and 79 same.
Ah.
Item
77, I have been same issue, my lord. Same issue.
77 and 79.
77, I am appearing.
You are appearing. All right.
And
Put down
79
as
also
appearing.
same.
Then you don't say none appears. In 77, you put down as appearing. All right. All right.
Item number 43.
Ma'am, the petitioner, the appellant has challenged the order of the Honorable Single Judge, my lord, wherein Honorable Single Judge has been rejected my claim, only 1 mark short for my pass mark for the examination Orissa teacher eligibility test, my lord. Though as per guideline, the question should have kindly see the order, my lord. And kindly see for a moment, kindly see page 36, the syllabus. For OTT examination, Orissa teacher eligible test examination, my lord. 36, my lord.
Yes.
Paper 1. I am concerned with paper 1, my lord. For class 1 to 5th, my lord. But my stand is in my appeal, my lord. The question which has been put in the examination do not been not from the class 1 to 5th, my lord. It is the question from 8th to 10th standard was there, my lord. Thereafter, in his identical cases, this honorable court has passed his judgment, my lord. Kindly see the judgment, my lord. In another case, copy. Paragraph 3, my lord. Single bench judgment. Paragraph 3. Mr. and Mr. Lorna, counsel for the petitioner strenuously urged that before this court that as per the textbook prescribed for class 7th by the Board of Secondary Education, Odisha, that is Sahitya Saurav, option B, which is the correct answer to question number 12. If the authority has prescribed the syllabus for NRTS examination 2016 as per the syllabus of class 7, it should not have subsequently denied the claim of the petitioner relying upon certain description made in the dictionary, which is contrary to provisional. Here in this case, the question is to be fixed for the class 1 to 5th, my lord. And only 1 mark short for my lord for qualifying in the examination, my lord. I have secured 89.89 mark. 90 is the pass mark, my lord.
Let's see the impugned order.
Page 42, my lord. Mr. Arun Parja, the petitioner has filed this application seeking direction to the opposite parties to consider her case by awarding 1 mark on question number 7 of English paper set A and declare her as qualified in OTET examination 2016-2. Mr. B. K. Man, the Learned Counsel for the opposite party board of secondary education of Odisha files counter affidavit in court today. Paragraph 6 thereof is extracted hereunder. That it may be stated that after the 2016 OTT examination, several candidates raised objection to the award of mark to various questions. Such objection with regard to question number 7 also. The board authorities have referred the questions that were objected, including the question number 7 of English set A before the question analysis committee. The question analysis committee, after examining the answer paper, found the answers to the questions provided by the board is correct. That is answer D. The question analysis committee relied upon the documents Oxford Advanced Learners Dictionary, page number 749 by S. Hornby, 2010, and other grammar books. The copy of the report expert committee is annexed herewith as Annex A by 1 to this counter affidavit. Thus, no useful purpose will be served even if the matter is referred to the question analysis committee. In view of the fact the matter is...
So the answer key is not wrong. Why should there be an interpretation?
The answer should have from the class 1 to 5th, my lord.
That's not the ground here, sir.
But I have taken that ground in my appeal, my lord. In my appeal, I have taken that ground. And I have also annexed the syllabus, my lord.
What we urge with the single judge is what we are going to examine. No new ground here.
I have annexed the syllabus.
Yes.
From the syllabus, the OTT examination should have been conducted.
No. There your answer was that your ground was that
only 1 mark, my lord, short for
ground
for qualifying for the examination. Yes. From the syllabus, which are annexed, my lord, the question should have come from that syllabus, my lord.
To challenge the present petition is to an order dated 26th February 2020 passed by a single judge dismissing the appellant's writ petition civil 16701. 1670 is it? 1670 of 2017. Full stop. The prayer in the present in the said writ petition was for a direction to the opposite party to award the appellant 1 mark on question number 70 of the English paper, set A. Declare her qualified in the OTET examination 2016, bracket 2, bracket. The learned single judge took note of the stand of the Board of Secondary Education, Odisha, in its counter affidavit that the very prayer of the petitioner had been referred to the question analysis committee, bracket QAC, bracket, which after examining the answer paper, found the answers to the questions provided by the board to be correct. That is answer D, capital D. Paragraph, the QAC also relied upon the Oxford Advanced Learners Dictionary and other grammar books to confirm if the answer was correct. Paragraph. Factually, therefore, it appears that no ground was made out by the appellant regarding any error in the answer key. Paragraph. In the circumstances, the court is not inclined to interfere with the impugned order of the single judge. The appeal is discussed.
Item 44.
Your Lordship. Lordship.
44, kindly pass over.
Lordship, I am for the appellant, Your Lordship. Lordship, they are filing an affidavit.
No, what's the delay?
Your Lordship, the issue pertains to reversion of from senior assistant secretary to the post of Hindi officer. Your Lordship, the Honorable Single Judge has not taken into consideration
three aspects, Your Lordship. One is that recruitment rules do not provide the post of Hindi officer. And second is there is a limitation. There is a delay in filing a rate application, which has not been explained. And third is, Your Lordship, there was no vacancy from 4/9/2012 to 31/16/2013. And fourth, Your Lordship, the DPC has not been held in the meantime from 2013 to 2017. What has happened in this case is, Your Lordship, the respondent number 1 was promoted to the post of Senior Assistant Secretary on 23/3/2013, and he was again reversed back to Hindi officer on 4/9/2013. On the ground, Your Lordship, the one Sri A.K. Samal was promoted to the post of Deputy Secretary. He was also reverted back to the post of Senior Assistant Secretary. So there was no vacancy at that point of time. So the respondent number 1 was reversed to Hindi officer. And these are the, Your Lordship, may kindly have a glance at the order.
No, but he already got promoted by the DPC.
Your Lordship, he got the promotion and he was also reversed on 4/9/2013, which was challenged, which was assailed before the Honorable Single Judge. And he has filed this writ application after 5 years, assailing the promotion of one Sri Parotudu, who has been promoted on 29/1/2017.
He's already filing a counter in the writ appeal.
They are filing an affidavit.
No notice is issued, nothing. You're still filing an affidavit.
Lordship, kindly pass through our senior. Just pass through.
You have served an advance copy in you.
No, they haven't served.
All right. Notice. Who's appearing for the opposite party?
Your Lordship, Mr. Devendra Mahanta, Your Lordship. Devendra Mahanta.
He accepts notice for respondent 1. The Paradip Port Trust is to be served, no?
Your Lordship, I am the appellant.
No, sorry, the Union
of India.
Notice, Mr. P.K. Pade accepts notice for respondent 2. Is there any contempt case?
As per my knowledge, I do.
All right, just notice on stay also. List all. 16th August.
Item 45.
Similar matter has been fixed on 17/5 matter. The substitution is necessary. Appellant number 2 died.
When is the matter coming up? Show us that order. Similar matter order, show us, sir.
In the WA 269 of our.
Why do you must be having? Must have applied and got a copy of the order.
What's my that's the constitution.
You don't even get order in your own case. You don't take office.
Same case, my lord. Only 5 cases, my lord, fixed on 17. So this is left out to one case. I filed memo and it came before my lordship.
We understand. We remember so much. We remember, sir. We're just asking you a simple question. Do you have a copy of the order that we passed in those cases?
If my lordship after recess, my lord,
all right.
After recess.
After
recess, my lord, I will supply. After recess, I will supply. Uploading some difficult.
All right.
Pass through.
After recess.
Pass.
Item 46.
My lord, this is also that writ appeal relates to Sarat Parida case. I am passing over to him. Okay. It is adjourned to 8th of May, my lord, the batch of.
Same order. Okay. Same order.
Item 47.
Here the learned single judge has passed the order granting 4 lakhs plus 7% interest without taking note of the amendment to the rules 2017 as the Reena Devi case 2019 Supreme Court, where the Honorable Apex Court has held that either 8 lakhs or 4 lakhs plus interest, whichever is more, that is to be awarded. That is my sole view.
The facts have to be discussed.
Here the Honorable Singhvi Judge has awarded 4 lakhs plus interest at the rate of 7% per annum. And in view of Rina Devi case, that is 2019 Supreme, I am giving. That's para 19. Page 583. Paragraph 19. Last 5 lines. Compensation as applicable on the date of accident has to be given with reasonable interest and to give effect to the mandate of beneficial legislation. If compensation as provided on the date of the award of the tribunal is higher than on revised amount with interest, the higher of the two amounts has to be given. Here either 4 lakhs with interest or 8 lakhs, whichever is more on the date of award. So that is to be given. In the present case, the Honorable Singhvi Judge has granted 4 lakhs plus interest at the rate of 7%, that is lesser than the 8 lakhs, which is the amended schedule of the rules, amended rules. I will annex the rules, annex 3, page 39. This was with effect from 1st of January 2017. And the order was passed in the year 2020.
But is it a uniform rule across the board for all cases?
Yes, sir. This rule is known as
Or who's appealing for the railways?
child or notice.
Or notice returnable. Eleventh May. Yeah.
Item 48.
48, my lord. It's the electrocution death case. And the Honorable Singhvi Judge has granted penalty amount of 2,50,000 as compensation without assessing or quantifying the compensation amount. Even as per MV Act also, this amount should be, I have taken that ground, 5,40,000, 9,15,000. You see at a glance, without any assigning any reason, the Honorable Singhvi Judge has granted 2,50,000 consolidated amount on account of death of a NMR employee in an electrocution death case. You see page 32, running page 32.
All right, notice returnable same date. 11th.
Item 49.
Mayor, please, Lordship. Mayor, please, Lordship. My lord, kindly pass over my lunch.
Item number 50.
Lordship, turn to page 74. That is the granting of UG scale relying that Alok Mishra case. Your Lordship has already, that is pending for the honorable approach.
When is it coming up?
First February.
First?
February.
Ah, it's just 3 days.
That is coming before that. Honorable Apex, but that it may be adjourned.
Ah.
After disposal of that.
All right, you list this on 1st February. Let's
51, 52, 53, and 77.
50, 51, 52, 53.
51, 52, 53, and 78.
Item number 54.
54. My lord, the last order, my lord. 11/7/22. Lordship were directed to file the affidavit. My lord.
Item 54 minutes. We have filed it on 27th. Let me give copies of the.
What is the last order?
Let's had as just to ascertain the present case of the status of the. There were 4 FIRs.
13/1/22. That's the last one. 11/7. 11/7/22.
11/7.
Please. None of the matters, my lord's progress has been made. So. My lord,
they are not sought the copy, my lord.
I've given the copy to you.
No, the copy has not given to me.
It's all.
What is no progress at all, sir?
No.
Why? What is this going on? 2012 matter, not even one prosecution witness examined. What is the reason?
Well, as 3 of these matters were transferred to the ADJ's court in 2021. Let me see at para 5. Special GR case number 28 of 40 of 2012/21. Those were transferred in 25/11/2021.
Then more than a year is over.
Please, as we are taking expeditious steps,
Not expeditious, sir. 2012 matter, not even one prosecution witness examined.
As may fix a timeline, we will adhere to it and
the affidavit dated 27 January 2023 of the inspector in charge, Latur police station, has been produced. It appears that in the last, despite GR case having number 31 of 2012 being registered more than 10 years ago, and there being 109 accused persons and 22 PW prosecution witnesses, bracket PWs. Not even one PW has yet been examined. Paragraph, the affidavit further states that 3 other cases were transferred
court of the ADJ.
To the court of the ADJ Patnagarh on 25th November 2021 itself. So even in this case, there appears to be no progress as far as the trial is concerned. Paragraph, reports be called for from the SDJ Patnagarh as regards GR case number 31 of 2012 and from the ADJ Patnagarh as regards GR case numbers, special GR case numbers 28/40, 33/41 and 35/42. Explaining why these trials have not progressed. Paragraph, on this part, the IIC will place before the court an affidavit setting out the dates on which he proposes to have the PWs examined in the case and the outer time limit within which the entire trial will become concluded. The affidavit will be filed not later than 10th April 2023. List all. 13th April.
Item number 55.
Let us supply the copy of the affidavit, 2 days affidavit.
Already, I'll apply a copy.
Item number 55.
May I please, my lord? My lord,
55, I'm appearing on behalf of the petitioner. Lordship, we are challenging the temporary.
my lord, may I pray for Passover, my lord?
All right.
Item number 57.
My lord, this is 43 assessment, case of automobiles, my lord. 57, my lord.
Covered.
Yeah, let's see. The first one is anti-tax. ECMAS resins. The
ECMAS.
second one is.
First one, you say in view of the judgment in ECMAS resins, the impure assessment order. And all proceedings pursuant thereto. I hereby quashed. The second one, in view of the judgment in case of automobiles, affirmed by RTCs. Same order.
Obliged, my lord.
Item 58.
May I please, my lord, the petitioner state government undertaking, my lord, challenges the levy of a fee under 234E prior to 1/6/2015. My lord, my paragraph, page 8, my lord, 6.1. With effect from 1st June 2015, the amendment made and inserted in the 200A section levy of fee at C, my lord. And this issue is now already settled by different honorable high courts, my lord. And in the recent judgment of 2022 order, I'm now judgment providing, already settled by different honorable high court that it prior to 1/6/2015, under intimation 200A, levy of fee under 234 it cannot be made.
The notices issued, my lord, after the date of commencement of the new provision, my lord, that is illegal. But here, notices has been issued, my lord, prior to commencement of that 200A, my lord, provision. 134E, that mandates, my lord, for submission of the statement in time. Otherwise, for one day, that there will be fees of rupees 200. Till, my lord, it has been filed. So, my lord, once it
You
has
not filed any reply, sir. Notice was issued in the petition way back on 22nd December 2016. Oh, you have filed a reply.
In this case, reply has been filed.
One minute. Let's see. But you have not dealt with this judgment.
No judgment.
You're not aware.
My lord friend.
Counsel of the petitioner relies on the decision of the Kerala High Court in Olari Little Flower Kuris Private Limited versus Union of India. Bracket, say 2022, 440 ITR 26 bracket KER, and states that the issues raised in the present petition stand answered entirely in favor of the petitioner by the aforementioned judgment. Counsel of the department seeks time for instructions on whether any appeal has been filed against the said judgment in the Supreme Court.
Item 5967, my lord.
It's on 14th August.
59 and 60. Item 61.
Let's see this item number 61 and 62 are the penalty under section 65(2) for violation of 65(1). Identical matters, your lordship has directed me to take instruction. Your lordship, so far the jurisdiction is concerned, that is
no, my
satisfied.
lord, I'm not on jurisdiction. Your lordship may kindly see 65(1)(a). It says that I have to oblige to file the closing stock in the manner prescribed. This came into book in the 2008, and the rule has never come.
Exactly.
And therefore the very provision became unworkable, and for noting down that violation, I have been penalized.
On that respect, your lordship has directed me to take instruction in those matters, and those matters, my Lawrence Superior is also appearing in those matters. Those matters have been adjourned. So all these 4 matters may be adjourned. Only point that in absence of that prescribed.
Those are adjourned to which date?
Your lordship, that my Lawrence Senior is also in that case. Your lordship,
I was appearing.
No. Two other cases. Your lordship, in the launch, I think April. Your lordship, particular date.
All right. Just pass over. We'll give it the date.
Your lordship.
All right.
62 also. Item 62.
Yeah. Same.
62 is the same. 61 and 62 both matters.
Item 63.
Name placement. I'm on the petitioner. Matter regarding deduction of TDS from the interest avoided by the land tribunal, motor accident claim tribunal, my lord. My lord, your lordship can have glanced to Annexer 5 at page 31. That dated 18/11/2019 of OP number 4. So in pursuance to my legal notice, dated 30th October 2019, that it's OP number 4 informed that the amount your lordship can have glanced at the last 3 lines of the tabular columns. That's petition number 1, Unisau. The interest payable was 2,15,834, out of which 43,167 has been deducted across TDS. And in the similar way, from this opposite party, petition number 2, that is she was entitled for this interest on the compensation 2,15,833, and out of which 43,167 has been deducted, and she has been paid 1,72,666. Similarly, the petition number 3, that he was entitled for 2,15,333, and out of which 43,067 has been deducted towards TDS, and he was paid 1,72,266. My whole contention before lordship is threefold, my lord. My first contention before lordship that TDS is in case of this, while in keeping with section 171 of the Motor Vehicle Act in 1988, this whenever the line tribunal passed the compensation, he has to pass the interest, which is the part and parcel of this compensation, that is for the forbearance of the interest because of the money being held up, because this opposite party neither so much given the compensation nor considered my claim. Rather, they have contested in vehemence, pursuant to which the matter was lingered and the interest was paid. I am placing before lordship, that is section 171 of the MB Act.
Who's for the other side? Who's appearing for your 2 and 3?
I'm
for the department. All right.
May I please, Maila?
Yes, yes.
Award of interest where any claim is allowed. Where any claims tribunals allows a claim for compensation made under this act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date, not earlier than the date of making the claim, as it may be specified in this year. Therefore, my contention before lordship, that is this interest, though the rate of interest each discretion on the part of the land tribunal, however, it is given in addition to this compensation for the forbearance of the detention of money. And my second contention, therefore, the deduction of TDS is illegal. And before my second contention before lordship, that even though they have deducted the TDS, which I came to know only on 18/11/2019 by Annexer 5, that they have never, the petitioners are in possession of the PAN card. They are income tax holders. At no point of time, they have ever been informed about the PAN card. And also at the same time, they have no occasion to inform the OP number 4 whether this is required or not. To that effect, I will cite before lordship the decisions of this Himachal Pradesh High Court and also this Bombay High Court, my lord, and the Madras High Court also. My third contention before the lordship, that is which is illegal under 206 or section 206A of this Income Tax Act. My third contention before Lordship that by your Lordship,
yes,
by virtue of this order of this Honorable National Commission and National Lok Adalat, this matter was settled on 13/7/2019. Your Lordship can have glance. Annex 2, my lord.
Yes.
Your Lordship can have glance to turn to page 26, my lord.
What happened after that?
My lord, yeah. Thereafter, this Honorable National Lok Adalat directed to pay the amount whichever is being modified, that is 15 lakh, along with the interest payable, that is 7% within 8 months, within 8 years. However, they are paid after this 15 weeks. And that your Lordship can have glance. This is Annex 3. At page 28, my lord. Your Lordship got it? Your Lordship can have here after this 5th line. The insurance company, that is the National Insurance Company Limited, has already deposited bearing check number so and so, amounting rupees 5,85,000. Check number so and so. Check number so and so of rupees 2,55,000. Check number so and so, amounting rupees 2,50,000. Check number so and so of rupees 1
Don't go on reading, sir.
My lord, your Lordship can have. This on 20th/9/2019. That's on this Honorable National Lok Adalat directed to pay the compensation along to interest within 8 weeks. That is being passed on 13/7/2019. So here they have paid on 20th/9/2019 and it deposited on 15/10/2010.
What's the delay? What's the delay?
That is 1 month, more than 1 month.
That's all right.
My lords. So my contention before that they need to pay also the compensation, that is 9,250,000. To that effect, I am citing the decision of this Honorable.
All right.
My lord. Honorable Bombay High Court on 8/8/2019 in Sri Rupesh Rashmikant Shah versus Union of India. Your Lordship can have glanced at para 63. Though I have relied on number of paras, but I am placing for Lordship para 63. At page 61, your Lordship can have my written note of argument. Page 61. Para 63, my lord. May I place, my lord?
Yes.
In the result, we find that the assessing officer had committed an error in levying tax on the interest component of the compensation awarded to the petitioner till the date of the judgment of the High Court. On any interest paid to him post the judgment, tax had to be collected as income from other sources. We therefore set aside the impugned order of assessment and place the assessment of the petitioner back to the assessing officer for passing fresh order in line with the judgment. My lord, second my decision, my lord, that's Honorable Himachal Pradesh High Court. The para 23, though I have relied on 13 and 23, I am placing before Lordship this para 23, which is squarely applicable in this case, my lord. Page 68 of my written note of argument.
Yes.
Para 23, my lord. Having said so, the circular dated 14/10/2011, where it is being levied for this TDS, for this interest on this compensation, my lord, that I will that I have also cited on this page 1 of my, that's page 6 of my written note of submission, my lord. The circular 1410/2011 issued by the income tax authorities, whereby deduction of income tax has been ordered on the award of amount and interest accrued on the deposit made under the order of the court in motor accident claims case each quashed, and in case any such deduction has been made by the respondents, they are directed to refund the same with interest at the rate of 12% from the date of deduction till payment within 6 weeks from today. My lords, my third decision, which I am relying before Lordship,
Madras,
Honorable Madras High Court, my lord.
Sinnadurai, Managing Director.
That is para 18, I am relying before Lordship, that is at page 72, my lord.
Yes.
Hence, with due respect, I am unable to concur with the findings of the Karnataka High Court, the Chhattisgarh High Court, and this court cited by the revision petitioner. This court is of the view that the division bench judgment of the Himachal Pradesh High Court and the judgment of the single judge of the Punjab and Haryana High Court lay down the right law, and hence this court arrives at the conclusion that the compensation awarded or the interest accruing therein from the compensation that has been awarded by the motor accident claims tribunal cannot be subjected to TDS, and the same cannot be insisted to be paid to the tax authorities, since the compensation and the interest awarded therein doesn't fall under the terms income as defined under the Income Tax Act 1961. My fourth decision, which I am relying before the Lordship, that is Honorable Madhya Pradesh High Court, my lord, which is the para 19, I am relying before Lordship, placed at page 79 of my written note of submission, my lord.
Yes. Oriental Insurance. This is Kalabai.
My lord.
Yes.
In the case of Ramyal Supra, this court has held that it is the responsibility of the insurance co.
Or it's the same judgment, don't have to repeat. Yes.
My lord.
Yes, please. All these judgments are against you.
Yes, my lord, I have gone through, but Lordship may consider that is, my lord, an income that has been incorporated in section 56(1).
So what about these judgments, sir? All these judgments hold against you. Consistent judgments, Bombay,
But so far,
Kerala, Karnataka, Madras,
yes, that is there.
Himachal Pradesh.
I have verified, my lord, due to low limit of revenue, my lord, that these have not been challenged before the Honorable Appeals Court.
That's the end of the matter, sir. Then it's covered against you then.
These are disputed tax, my lord, regarding deduction of tax, my lord, by the company. The company, my lord, which his contention is, he challenged the delay of payment for that.
In fact, for making this petitioner come again, you should also pay costs.
That is one point is only limited that
TDS cannot be
whether
deducted from the
interest on the compensation amount that amounts to income, and TDS is
judgment goes.
That is the point.
Okay, the writ petition is allowed.
There are so many cases also pending before this honorable court. There are so many cases also pending in this honorable court, millards, in respect of this millards deduction of millards.
TDS on interest.
Exactly, exactly.
Give us the numbers.
That's.
Then we can get them listed. After today's order, we'll get them listed.
And secondly, millards, as per section 194A millards, we have to millards deduct the millards, TDS millards.
We have to refund it all now, sir.
Because we have already deducted and we have given to the millards department millards. So we have given also.
That's what we're asking the department only to refund, sir. You stop deducting hereafter. Citing this judgment, you have to stop. Your writ petition is allowed. The TDS amount wrongly deducted from the petitioner will be refunded to the petitioner. Not later than 8 weeks from today, failing which simple interest at 6% per annum on the said sum will be paid to the petitioner for the period of delay. That will be the operative portion.
But department is directed.
Department is directed, yeah,
Wherever
by
it
the
is-
department, by the income tax department.
Wherever it is paid, my lord, wherever they have paid.
No, no, where else they can't, you would have proceeded against them if they're not paid. Once it is deducted, they have to deposit it automatically in the treasury.
Beg your pardon.
All right. Yes.
Beg your pardon, me, let that item number 61 and 62 maybe adjourned to 24th April 2023 along with WPC number. I have given the sheet.
All right.
Identical matters.
All right.
Item 64.
May I please, your lordship? But I am through BC, my lord. Here, my lord, demand notice has been issued on the basis of government land. The shop was open on government land. It is covered by lordship's order.
Same order.
That is covered by Ashok Kumar Jana's case.
Right.
But next item 65 is not pressed.
All right. 65 dismisses not pressed.
Item.
Same order.
Item number 66.
66 permitted to withdraw.
Dismisses withdrawn.
Item 67.
67, 68 and 69, my lord, permitted to withdraw.
All right. Dismisses withdrawn.
Item number 70.
But 70 and 71 TCS matter. That is also covered by lordship's order. Judgment.
Lordship, I am appearing for the opposite party corporation.
All right.
In this case, your lordship.
So blessed.
Who was BC? That whole bunch.
Item 72.
May I please, your lordship, my lord, this is a TCS matter.
This shop located at all these places has changed. Right?
My lord, I have corrected.
That give us the corrected one.
Item 73.
None appeals.
Item number 74.
May I please, on behalf of Bundaban Raut, your lordship, that is a filed a writ application that license has been given to open the annexed 2 men. Time of operation was 12 noon to 12 noon midnight, and subsequently by the annexed 4, they have modified at running page 17. They have modified to close the shop on 8 p.m. On basis of that, I have filed a representation by the annexed 6 before
I
the
think that
authority.
is also changed. Now 8 p.m. is no more. It is a old case. Now 8 p.m. is already extended. I think you get instruction from your cadet.
No, but his shop is not working.
Yes, ma'am. Not working, my lord. Till now, it's continuing. But the time is they
It's
have
on stop. He is claiming that it should not be closed by 8 p.m. because of the impugned notification. Now, I think that is changed. 8 p.m. has been extended.
a similar situated person. They have allowed to 12. I have already filed in my representation before the authority. By the annexed 6, your lordship.
No, what is the relief that can be granted? I don't understand.
He is challenging a notification in which the excise department has directed to close down all the on-shop at 8 p.m. That is a year-old notification. Now it is extended. So if he wants, then the excise commissioner may be directed to consider the representation. That can be done. But it is already, his prayer has already been addressed.
That notification has already been gone, my lord. So superseded.
Then it's infractuous, sir.
No, man, that 8 p.m. Notification already been superseded. But till now, that though my file a representation to consider my case to open the shop for 12 to 10, till now they have not considered, even though that has been superseded. That is pending before the authority.
if it is superseded, then the new notification will be abide.
Absolutely.
Then how you are saying that?
It's uniform, sir, for everyone.
No, that is not the pleading. He is saying that even if it is superseded, we are not allowed to operate this
I have
soft till.
already narrated that similar situated person you have allowed at that point of time.
There is no similarity. Whatever the notification, it is applicable to all.
Yes, ma'am.
Not only the petitioner, but all.
Pursuant to new notification, are you not functioning?
Till now, I am functioning.
Pursuant to new notification, your shop must be continuing to that extent.
Yes, ma'am. No, I am continuing.
And then
What remains, sir? Where is the cause of action surviving? There's no cause of action surviving. In view of the supersession of the impugn notification by a fresh notification, no cause of action survives. The writ petition is disposed of.
Item 75.
Your Lordship, item 75, no cause of action survives.
All right, no cause of action survives. Petition's appeal is disposed.
Obliged.
Item 76.
None appeals.
So item number 76, I am for OP number 2, my lord.
All right.
I present the
Noted.
time.
I am for OP1, man.
All right, sir.
For hearing item 80.
Again, that same
80 Miller, I prefer on after lunch. Sorry? After lunch. Ah, sure, after lunch.
Pastor matter item number 32.
Well, let's
see,
previously this was going on, whether it is a division bench matter, then single bench matter. After your lordship in 8 matters issued notice and stay granted. Then my learned friend for the transport department said, no, this is a single bench matter. Now I'll explain in 2 minutes how it is a division bench matter and why it has been listed before lordship, because it comes within the residuary list. Whether the petitioner initially challenged the tax and penalty in 2015. In 2015, after challenging this, during the pendency of the writ petition, a CIRP proceeding was initiated.
Yes.
Claim was invited. The transport department had a Kumbhakarna Nidra. Then, my lords, a resolution process was, resolution application was submitted by the resolution applicant, which was accepted by the committee of creditors. Now, 78%, 5% vote. Then that NCLT awarded the same matter, went to the appellate tribunal. Appellate tribunal confirmed it on 13th of December 2018. And my lords, by way of an additional affidavit, I inserted these grounds. Now, the learned single judge, lordship may be pleased to see Annex 9 at page 79, para 8, 9, and 10. These are the 3 most important paragraphs of the learned single judge, where the learned single judge has said that this has to be by way of an amendment. Then I filed amendment as well as the fresh writ petitions. Then the first writ petition of its own was listed this honorable court on 3rd. And this honorable court, my learned friend was present and I read para 10 on that day, and learned standing counsel appearing for the opposite party transport department does not dispute the aforesaid position of law on which reliance has been placed by the learned counsel for the petitioner. However, he submitted that in the writ petition no such prayer was made. It is true that when the writ petitions were filed, the aforesaid fact was not in existence, but later on the proceedings have been initiated in the year 2017. The petitioner could have very well amended his prayer and that the claim of one of the financial creditor is subject to NCLT proceeding, and as such the claim of the OP, if any, is required to be adjudicated in the NCL proceeding there. Further, even after the approval of the resolution plan, the petitioner has not amended the writ petition. Simply he has brought the notice of the court, the subsequent development from the resolution, full stop. From the resolution plan at Annexure 7 at page 7 to 215 approved by the adjudicating authority. It has also been clarified, clearly mentioned in clause E 2/2, E 2/3, clause 7.1.1, 7.1.2 that SML has, that the petitioner has outstanding statutory liability of rupees so and so crores as on 2017, and it has also various litigation by the financial operational creditors as detailed in the plan. In addition to the regular operation creditors, the SML has also certain old operational creditors whose outstanding amount payable as on 31/2017 stood at rupees 36.49 crores. So also as per the resolution plan, the liquidation value applicable to the operational credit is nil. The total operational credit are coming to rupees 36.49 crores. Stream Metallics Limited proposes to settle the same as an average level of around 30% in a gradual manner, although the liquidation value is payable to the operational creditors. Well, so and so, he has written, my lords, the learned single judge, the learned single judge has quoted the next page, Lordship may kindly see page 91. Therefore, notwithstanding the law laid down by the Appeals Court in the case of Ghanshyam Mishra and Messrs. Ruchi Soya Industries and Rajesh D. Darbar, this court is unable to accept the submission of the learned counsel for the petitioner, but the petitioner having a prima facie case. This court disposed of all the writ petition, giving liberty to the petitioner to approach this court within 2 months hence, if so advised by filing appropriate petitions incorporating the appropriately and prayer, and till then no coercive steps shall be taken. And thereafter, my lords, immediately after 2 months, my lords, applications were filed and also writ petitions were filed, my lords. And thereafter, how this matter has come before Lordship. It is not that it is a residuary matter. It is not. It is a completely IBC matter, my lords. And your Lordship of this same petitioner has in irrigation matter, my lords, 8259, there is a leading judgment of this honorable court, where the claim is not submitted by the operational debtor, then the plan becomes final and the NCLT judgment becomes final, my lords. So this is how, and your Lordship have posted the matter, having granted no coercive action, posted 8 of the matters, my lords, have been posted to 8th of May, and only on 3 matters, my lords, Lordship have simply said because of
where is that, Mr. Bera? It's not there today. Or list on 8th May.
There are interim application, my lords. Interim application is there, my lords.
What's the order in the other matters?
My lords, order matter. Yes, I'm giving matters. Lords.
You say, although Mr. Bera, the last occasion, had raised an objection about the matter being taken up by the division bench, it appears that other connected matters are in fact before the division bench. So notice Mr. Ishwar Mohanty accepts on behalf of opposite party number 3, Mr. Behra on behalf of 1 and 2. Replies within 8 weeks, regarded before the next date. No coercive steps till the next date. List on 8th May.
Much obliged.
You see, the question whether the matter should be heard by the division bench are left open to be urged on the next date.
Yes.
Item 33.
Same. 32 or 33.
33.
Right. 33 is the same. Correct.
Item number 45.
Order I have also given.
Same order.
70.
Same order, same date. All right.
Item 49.
49.
Item 49.
None appears despite a passover. Dismissed.
Item number 55.
Lordships, the petitioner are challenging the temporary permission granted to opposite party number 4 for conducting mining on the conducting mining, and so also are seeking recovery of the ST land taken over by the opposite party number 4. Lordships may see that at Annexure 2, proceedings under Section 3A have already been initiated, and as per the counter, the opposite party number 4 has admitted that they have appeared in the said proceedings. Lordship may direct the expeditious disposal of the same.
In the counter affidavit filed by opposite party number 4, it is admitted that proceedings have already been initiated against it under the. They have filed the memo. In memo, we put the you see, under Regulation 2 of 1956. So, in that view of the matter, the court is not inclined to interfere in the present petition, leaving it open to the parties to work out their rights and remedies in those proceedings in accordance with law. If not already disposed of, the said proceedings should be disposed of as expeditiously as possible and preferably within a period of 6 months from today. I am but the opposite part. Right. We'll take it up.
56. 56, I am appearing for the Pollution Control Board. I have filed the affidavit as per direction of your lordship.
We're just seeing that.
I have also enclosed a pen drive containing the entire video recording of the proceedings.
All right.
May I presume, my lord, because I am for the petitioner, and perhaps your lordships may be able to dispose of the matter in less than 5-7 minutes, because everything which your lordship had wanted to be in accordance with law has been done.
Okay.
And now let us say 2-page note, if my colleague will hand it over. I've summarized how your lordship may not have to spend some time if my colleague wants to.
Just give him a copy, Mr.
Dhruv will give a copy.
I received a copy, my lord. I received a copy and
I am the opposite side number 8, Willis. I just 2 pages. I've tried to summarize pursuant to my lord. That is after my lord's order.
Right.
Now, Willis, the petitioner had sought setting aside of public hearing conducted on 22 November, etc., plus direction of fresh public hearing. That is prayers at so and so. Both, Willis, that is why we were opposing actually very, very briefly, and your lordship said so. And I was persuaded my people that actually this may be a much better solution rather than arguing on that.
Right.
And subsequently, the public hearing was held on 7th of January 23. There may be a typo there.
No, 7th December 22 only. Or January, right? 7 January 22.
Hearing was held on 7 January. That's a typo.
Correct.
In
7 January.
compliance of the directions passed by the Honorable Court in the presence of neutral observers, so and so, the State Pollution Control Board, that affidavit just mentioned to your lordships, placing on record the entire public hearing together with the video. The writ petition must therefore now be disposed. Nothing further remains to be done. That's point 1. Point 2, Malus. Part 4 of the notification, the details are given, Malus. I am opposite party 8. My counter has it at 4950. Contemplates a separate procedure for appraisal of the project for grant of EC. At this stage, the expert appraisal committee will also see the outcome of public consultations during public hearing. Now, just give me 5 seconds here. I can't get my EC, which is the most important document, because of an alleged vitiating factor in the public hearing. Now, that part is gone. And therefore, the whole thing held up on EC does not really survive, is my humble submission. The stage has not arrived, etc. Then, your lordship's direction, I am broken up, if your lordship doesn't mind, into 3 or 4 sets. The first set of your lordship direction are 1, 2, and 3. All statutory requirements and prescribed complied with. 1, these are the requirements the lordship wanted. First is fresh public notice for on 5/12 for 30 days clear time, indicating time 11:30, venue, etc., etc. They're all there, in the affidavit of the Pollution Control Board. Date and time of the hearing was intimated to the district judge. That is there. Date and time of public hearing was intimated to the district legal services and requested to be there. Date and time to the collector and district magistrate. Again, those pages and paras are there. Then, your lordship's second direction on the next page is adequate publicity. Now, this we have given your lordship Times of India and Samaj Annexure reference at page 9 of the Pollutions Board affidavit. Then, in addition, announcements were made through public address system on these 2 dates. That is prior immediately to the hearing in 19 villages located close to the proposed mine on 3rd and 4th, 2 days prior. Then All India Radio in Odia language. I don't think there is anything, any of the usual kind of cases your lordship may come across. Every attempt was made to be transparent. Then your lordship gave us other direction, number 4. Preside over by the collector, videograph, and observers. All that done. Then number 5. That is my para 4, your lordship direction number V, 5. Affidavit has been filed by the Pollution Control Board along with the minutes of the proceeding and the videography. Then, I have in addition said the Pollution Control Board report annexed. The compliances made prior to public hearing, 2,265 reps were received. 111 numbers of written representations were received before the public hearing by the office. 2445 numbers were received on the day of public hearing. 109 received at the collectorate. Issues raised by the public and corresponding comments of officials of Hindalco were minuted in Odia and English. Now, about everything possible, comprehensively is done. Public hearing peaceful, no restrictions, wish to attend. Those who wish to speak at venue are allowed, etc., etc. I submit that ultimately balancing is what this requires. Procedural due process is what it requires. Fairness is what it requires. The intention is not to hold back projects which are transparent. There is one last sentence. In the second writ petition would automatically go in my favor, if I may say so with great respect, once this thing is removed, because this is the basis of not granting me EC. It is the stated basis.
All right. We'll just hear the others, Dr. Singh.
Yes. So my respectful submission is, in a nutshell, it has been held up for a long time. It is only in the public good. There were some problems with the local hinterland, whatever it is, we've heard them now, Your Lordship should allow for it to proceed expeditiously. I'm very grateful.
All right.
My lord, on behalf of the petitioners in WPC 473, my lord, the public hearing was conducted peacefully, my lord. This time no hindrance. But the proceeding as reflected from the annexure F/1, my lord, does not reflect the version of the people what they have stated. Although there is videography is there, and people have stated many things.
So we'll ask the videograph also to be placed before that appraisal committee.
My lord,
not just this report.
Yes, but
the committee will look into the videograph also.
My lord, what happened, my lords? 12 to 13% they have spoken in Kui language or Desia tribal language.
No.
It has
anyway, your written representations are there.
Right.
So all that and the entire record will be placed before the appraisal committee.
Yes, ma'am.
Nothing will be held back.
Yes,
in
not
JSW matter, your lordship did say same thing. In JSW.
Not the proceeding they have stated, my lord. Proceeding they have omitted many things from the videography.
All right. If you want to give another response to this report,
yes,
that will also be placed before the environmental appraisal committee.
Well, that's
all right. All right. You say pursuant to the hearing, pursuant to the orders passed by this court on 1st December 2022, a comprehensive affidavit has been filed by the State Pollution Control Board Odisha, bracket SPCB, placing on record the copies of the notices issued in print, media, the copy of the proceedings held on 7 January 2023 and the videography of the hearings of the hearing held. Stop. It is stated that in all 2,665 representations were received, and these have already been sent to the Ministry of Environment and Forest and Climate Change on 13th January 2023. Full stop. It is stated, without contradiction by counsel to the petitioners, that the hearing was peaceful and all those who wanted to speak were able to do so. A total of 78 people orally expressed their views, which were noted. Full stop. Paragraph. Dr. A.M. Singhvi, learned counsel appearing for opposite party number 8, has placed before the court a note which essentially summarizes the contents of the affidavit of the OSPCB and also states that issues raised by the public and the corresponding comments of the officials of Hindalco were minuted in Odia and English and attached to the report of the OSPCB. Paragraph. Mr. Prashant Jaina, learned counsel appearing for the petitioner, raises an objection that the report of the OSPCB perhaps does not reflect exactly the views of the petitioners. Full stop. In any event, since all the representations submitted at the hearing have already been sent to the Ministry of Environment and Forests and Climate Change, the court is sanguine that the expert appraisal committee, which will now consider the entire matter, will take into account the contents of the said representations along with the report. Full stop. Additionally, the court permits the petitioners to file a note with the MOEF and CC not later than 6th February 2023 of anything that they wish to make, they may wish to say in respect of the report submitted by the OPSCB. Full stop. Likewise, Hindalco is also permitted to submit a note within the same date. Full stop. Yes, Dr. Singhi.
There may be a slight coordination required, although it can be passed here, but it can be passed jointly. The second writ is 28704 of 22.
No, we'll pass a separate order in that.
Very
I'll
well.
pass a separate order in that.
Very well, but your lordship may keep this open till the end, because when I tell your lordship, there should be no dissonance between the two. Your lordship finishes
Yes,
all of us.
All right, all right, all right. Then you say, Dr. Singhvi has pointed out that the process for grant of the environmental clearance will now resume from the stage at which it was, and that process will now resume before the expert appraisal committee bracket EAC bracket paragraph, without commenting in any event on what the EAC should be doing hereafter. The court only notes that the EAC will now proceed in accordance with law, taking into account the report of the OPSCB, the representations received at the hearing, and the notes of both the petitioners as well as Hindalco on the report of the OPSCB. Paragraph. Since the primary concern expressed in the writ petition was about the fairness of the public hearing that had been earlier conducted, and since that grievance no longer survives, the court does not consider it necessary to keep the present petition pending. Full stop. As regards all events that take place hereafter, it will obviously be open to the parties to seek appropriate remedies in accordance with law. The interim order is vacated, the petition is disposed of. Now, in the second petition, you said this is a writ petition by Hindalco.
Just one sentence before lordship dictates for us.
Yes, yes.
This writ, the impugned order at page 837 is 12-10-22. The sole ground of lapsing my or allowing my ML, my mining lease to lapse, is this lack of hearing and lack of EC in your lordship's first writ. Therefore, I will need only one order. Of course, I will have to get the EC, which I will get shortly, subject to all the legal process. But till then, this lapsing either should be stayed, or at least the allotment of the mine to some third party should not happen. Otherwise, there's nothing left for your lordships to decide in any matter.
All right.
May I submit one thing?
Yes, please.
In first case, we have filed the counter, which are disposed of and not, so nothing to say. But the second case, my lord,
now because that circumstance is gone.
Yes.
Because now the EC will, the process of granting EC or whatever the EAC will do it.
But my lord, this Central Pollution Control would have a say, because in this process, they have to, they cannot be.
We'll only say that this 12-10-2022 should not result in your altering the status quo. They should not be presented with the fait accompli that you've granted license to somebody else without the EC process being completed. All right.
It cannot be.
That Hindalco has filed this writ petition, questioning an order dated 12th October 2022, passed by the Department of Steel and Mines, Government of Odisha, treating the license granted to the mining lease, treating the mining lease granted to the petitioner over an area of 268.11 hectares in village Aligaon, Kakaramba, etc., under the Potangi Tahsil of Koraput district, as lapsed with effect from 28 March 2021 by rejecting the revival application dated 3rd December 2020. Full stop. One of the reasons for the impugned order was the delayed the delayed action taken by the lessee company for obtaining environment clearance, unquote. Paragraph. Today, by a separate order passed by this court in writ petition civil 473 of 2022, the process regarding grant of environment clearance before the Environment Appraisal Committee of the MOEFCC has been revived by this court. Full stop. In that view, the matter is directed that the impugned order dated 12/10/2022 will be treated as being kept in abeyance till such time the pending process before the MOEFF and the EAC regarding grant of environment clearance is not complete. Full stop. The effect of this will be that during the said process, no steps will be taken by the Steel and Mines Department, Government of Orissa, to grant the lease in question to any other third party. Full stop. The writ petition is disposed of with the above directions.
Deeply obliged. Deeply obliged.
My lord, the last order may be communicated to Steel and Mines Department.
Order.
Second order.
A copy of this order be communicated to the Department of Steel and Mines, Government of Orissa. Order.
I pass on this slip, my lord, appearance of associate.
Order. Order.
Pastor matter item number 80.
Yes, sir.
I'm sorry, my lord, because in the today also the same mistake has been committed. My name is not there in the list.
I know. But thank God you were there.
Yes, I'm prepared.
Even my name also doesn't appear anyway. The lordship will kindly see that order dated 5/11/21. Here their only objections the last para 17, the fourth line, the appeal is partly allowed to the above extent by clarifying properties in Goa. It is joint and partitioned between the two makers. Go in the exhibit N. That is what he was objecting. And so far as para 16 also, that is be go in exhibit N, the partition deed. And I have one more submission subject to your lordship's acceptance. The Go schedule in the suit was in respect of properties which were purchased by the defendant number 1 in his name. He was the Karta of the case. So now, my lords, he purchased from 1930 till 1956. The trial court says there has been a severance of status. Severance of status will only be when there is a partition. Admittedly, exhibit 9 is the partition date in 62. So till 62, there was no severance of status. So the blending should have happened, considered a blending, and this entire Go schedule that is an extent of 46 acres. Absolutely, it should be 50-50. Like recording his name, trial court says since it is severance of status and already partitioned, while he acknowledges that the exhibit 10, which is a partition date, is in 62 and holds it to be valid. So that is an error which has happened with the trial court judgment, which was not appreciated by the first appellate court, that is why I wanted to bring to your lordship notice, because it's already a judgment of the Madras High Court Division Bench, which deals with that joint family, the nucleus, and so far as blending. It holds that in the trial court held that the plaintiff the onus is on the plaintiff to prove that it is not the self-acquired property. But the law says otherwise. Law says that when the defendant says it's self-acquired property, the onus is on him to prove that it's a self-acquired property and will not go to the that hotpot, and it should not blend with the other properties. So, my lord, kindly, my lord, I'm just passing on that judgment.
You are all the branches of two brothers.
Only two brothers. The genealogy is admitted. Two brothers from the second wife, and others have all shared. Only two brothers, it should have been 50-50. The elder brother is the defendant number 1. The younger brother is the defendant plaintiff. So plaintiff filed after 62 in 74 suit that I have been wrongly have signed it. All properties were not involved, and specifically Go schedule property.
So Gauss schedule, our claim was that Gauss schedule property being 46 acres, which should have been blended with the other properties in Gauss schedule, and it should have been partitioned. So
Whereas
to
his
that
case is
respect,
self-acquired.
it is severance of status was not there till 62. And purchase admittedly happened from 1930 till 1956.
No, so did he lead? No, he was the defendant in this, correct?
Defendant number one did not give evidence.
I see.
His son gave evidence. His DW1. That is where the court should have taken advance inference, because he says that this is my self-acquired property. Court says. Now he should have come forward and said, no, I have purchased from my own income. He was eligible to say that, but he didn't come to the dock. So that is an advance inference the trial court should have taken against him.
No, he was around. He was around when that.
Yes, yes. Your Lordship will kindly see that para 4 of that
Madras judgment.
My Lords. Because nucleus is important.
Yes.
When the learned textbook writers of the past and such, Your Lordship will come to the word nucleus. It is on the 6th, 7th line.
Yes.
Your Lordship got that?
Yes.
The word nucleus, for instance, implies, according to the conscience, Oxford Dictionary, a kernel of aggregate or a mass or beginning meant to receive additions. But as the expression occurs in a standard treatise, such as Manet, there are other shades of meaning that need to be noted with care. For instance, the proportion of the nucleus itself in relation to the estate which is under judgment is only one factor. Where there is considerable, the presumption arises that this acquired property is joint property, and the onus certainly lies on the party alleging self-acquisition. But as Mullah at pains to emphasize, the income yielding capacity of the nucleus is equal and important factor. A family house in the occupation of members and yielding no income could not be nucleus out of which acquisition could be made, even though it might be of considerable value. On the other hand, a running business in which the capital invested is comparatively small might conceivably produce substantial income, which may well form the foundation of the subsequent acquisitions. With regard to the cases of this aspect, a reference might be made to the following as the most significant in the present context. First, we have 947 Privy Council. Next is, my Lord, 54 Supreme Court. May be noted upon the question, the onus, where it is clear that the nucleus could have formed a source of acquisition. In 1959, who emphasizes that the existence and the adequacy of the nucleus are primarily questions of fact. The presumption is certainly stronger, where it is the manager who is responsible for the acquisition, which he later claims to be his. This is our case, man. Because he is the elder brother. He was in charge of the property and he was cultivating in possession. So, my Lord, next para I would like Lordship to take note of is para 39. That is, my Lord, at page 22 of the judgment. Lordship got it.
Yes.
Para 39.
Yes. The legal position.
The legal position as to acquisitions by numbers of a family like the one under the constitution is clear. The family was one to whose members fluid resources were easily available. The evidence shows that member is due cash from the family chest for the mere asking, and as regards Narayan Iyer, even during the period of his father's management, he did not even ask. It was available to him for taking at his will. When a co-partner seeks to prove that an acquisition made by a member is partiable, the first task is to show that at the relevant time, the joint family had nucleus ample enough to enable the acquisition. If in this he fails, the person in whose name the property stands need not prove out of what funds he acquired the property properly to establish that it is impartible. It is well settled that if, in fact, on the date of acquisition by a member of a joint family of any particular item of property, the joint family had sufficient resources with the aid of which the property in question could have been acquired. The property should be presumed to be acquired from out of the joint family funds and so partiable property of the family. Of course, it is only a presumption. The person claiming the property as his own could show the contrary and establish the acquisition was without the aid of joint family property. This he could have done, but he didn't come to the dock. He did not testify. Now, my lord, next, my lord, is para 57. Your lordship will get that at page 32, my lords.
Yes.
Lordship, what? Amongst tenants in common, where one tenant is common, acquires property in his individual right with no intention of making it common property, the property will not be divisible. The second defendant or the first defendant, for what matter, or the fourth. In defendant, if defendant may have received the rents and profits of the share of the plenty for the third defendant in the properties which were admittedly ancestral and divided by the father, but the persons in possession did not become thereby trustees of the rents and profits so received on behalf of the others who have not joined in the realization of the rents and profits. My lords, thereafter, he notices one judgment of the English judgment. There is no fiduciary relationship between tenants in common of real estate as such, nor can one tenant in common on real estate, by leaving the management of the property in the hands of his co-tenant, impose upon an obligation of a fiduciary character. A co-sharer would continue to be liable to account for the rents and profits received by him in excess of his share. But even if he fails to maintain separate account of his lawful share, he is in possession of excess profits. The funds collected by him do not get impressed with the character of joint funds. There is no trust in favor of the person who have not joined in the acquisition of the profits or investments. Any property acquired with such income would be the exclusive property of the acquirer, and others cannot claim any share in the property, as Section 90 of the trust has no application to such a case. In order that it may imply, it must be established that the party against whom relief is sought availed himself of his position and gained advantage by so doing, and the advantage was gained in derogation of the right of the person interested in the property. A person standing in a fiduciary position who another cannot, by taking advantage of his position, gain exclusively for himself an advantage which he could not have obtained but for the position. There being no fiduciary relationship in this case, the purchases made by the second defendant and fourth defendant, which were presently considered, cannot be regarded as acquisitions by parties availing themselves of their positions and obtaining advantage in derogation of the rights of other sharers. In the circumstances, if it is established that any of the acquirers had realized more than his due share of the property from the common property, and with such funds acquired properties, he cannot called upon to hold the property for the benefit of the rest. There is no rule of Hindu law which provides that the property which is acquired even after severance of joint family, that is a different thing. It is prior to severance, prior to 1962. Another paramills your lordship I want to place, my lords. It at page para 10 at page 10. This is regarding blending.
But blending, you can see the blending.
Yes.
Para 10, my lords. Upon the theory of blending, which is the next relevant aspect, I desire to add a few words to the discussion of my learned brother, which includes references to the case law. Obviously, the expression blending is itself one of those unsatisfactory English expressions used in treatises on Hindu law, which have been acquired a particularized connotation to be distinguished from the literal or dictionary significance. For blending might be of income from separate property with income from co-personal estate, or equally, it might be of separate property itself with the co-personal estate. Obviously, very different consideration would apply, where a manager or other person in charge of a joint family estate chooses to treat what is indisputably separate property, which was of that character at origin, as joint property by throwing it into the common stock or hodgepodge. Whichever expression might be used, as contrasted with the situation of blending, where this has occurred prior to the acquisition itself with regard to the respective incomes from separate properties and joint properties, and subsequent accretions are made from such mixed fund. Now, my lords, here, my lords, he was in charge, the defendant number one. He acquired properties in his name. So that is the finding of the trial court with respect of severance of status is an error of law. And second aspect, that God should have been taken into account for partition.
I have already handed over the genealogy for your lordship's perusal. The branch of the second wife, plaintiff is one of the sons of the second wife, then the defendant number 1 is Baina. Now the claim is in respect of the purchase made by this defendant number 1 under the deed of partition exhibit N. This was claimed to be the joint family property, which is being registered, and it is claimed that defendant number 1 in fact purchased it. Kindly have a glance, the sons are already parties in the suit. Even the father, the lifetime of father also, sons are added as parties. They are very much in the suit, and one of the sons has deposed. Now, the question is being raised that the property is joint on the face of record, that it's a self-acquired property, and the ownership is being shifted to the defendant. Plaintiff has never proved that such a property is a joint family property.
No, which is why he's citing this judgment to say that onus does not shift to the plaintiff.
Yes.
The onus shifts to the person asserting that it's self-acquired property.
Document is there. I have cleared my onus.
How?
Document is there.
What document?
The document of sale, document of purchase.
No. Purchase prior to 62, prior to the partition, right?
I'm coming to that. Prior to what happened thereafter. After this purchase, kindly have a glance at the...
Were you maintaining separate accounts about your income and expenditure? So the whole question is, how did you conduct yourself? You were a karta. So there is a presumption, that's what he argues, that till the partition took place, anything that you acquired was from out of the corpus of the joint family.
So that is to be proved by the plaintiff. Joint family, nucleus has to be proved by the plaintiff. Nucleus has to be proved by the plaintiff. Now, kindly have a glance.
Are you disputing that there was a joint family at all?
So far as properties of the...
because if the partition took place only in 62...
It was there.
It was there. So where's the question of his having to prove the joint family?
Yes. Now, kindly have a glance at the admission. How the partition deed was executed. Kindly, I am just placing one part of the judgment of the Honorable Single Judge. Kindly have a glance at page 5. Page 5. About 10 lines from the top. After 10 lines from the top, a sentence beginning with, at the time of mutual partition.
Yes, between the plaintiff and defendant number 1.
At the time of mutual partition between the plaintiff and defendant number 1, the latter claimed Gauss-Edel properties to be his own, but on the insistence of the Bhadraloks and to avoid future trouble, he agreed to part with some of the properties in favor of the plaintiff. Consequently, partition was effected by a deed of partition. That means, at the time of this partition, the document was executed, even some of the properties which was acquired by the defendant number 1 out of his own income or self-acquired property, they were allotted in favor of the plaintiff.
That is your version.
No, that has been proved. That has been accepted. The document has been accepted.
No. This is only extracting what you have said in your written statement.
Yes.
This is not the finding.
No, this is not the finding, but ultimately...
This was your contention.
This document was accepted, even the PW1. He has accepted that in the evidence that he has gone to the sub-register office and executed the document. That is why the trial court as well as the Honorable First Appellate Court accepted the Exhibit N as the valid document. But a single item of property in the document Exhibit N, that is scheduled Go, was left as joint. That may be partition. I have also no dispute. But so far as the rest of the property is concerned, the self-acquired properties, which have been also
You're saying they are self-acquired. The whole question is, did you discharge your onus of showing that it was self-acquired?
Self-acquired document has been exhibited vis-a-vis this partition deed.
So again, the document will only show that you purchased it in your name by virtue of a registered sale deed. That's what it will show.
Yes.
The source of the money, was it from a separate account you maintained?
Yes.
Or was it that just an account of the joint family property?
No, even the source have been disclosed in the same paragraph, in the same page, page 5, that has been disclosed and proved also. The source have been page 5 from the term that starts from page next, the previous page 4. The sources have been disclosed. The sources have been, from the first line I am just placing. He emphatically urged that the ancestral properties situated near Subarnarekha River were always affected by flood, and so the income therefrom was not sufficient for the family maintenance. As to source from which he got the funds to purchase Gauch's properties, he has heard that his wife was the only daughter of Niasi Ghosh, who at the time of her marriage had given sufficient dowries. Besides, his mother-in-law and gifted so-and-so a decimals of land by gift of the gift debtor so-and-so to his wife. Out of the income from the aforesaid properties, the defendant number one acquired the properties.
This is just a contention, sir. Please don't equate this to proof. These are all contentions. These are averments in a written statement.
This averment, why I'm stating this averment has been proved by way of evidence. Even this gift deed has also been exhibited. Gift deed exhibited, and it has been deposed by the witnesses.
You have to show us how you proved this, sir. Merely saying that you proved will not be enough. How did you prove it is the question.
By way of evidence means the oral evidence and the document of this gift.
Anyway, if you do not want to refer to the actual evidence led by you, then it's up to you. You argue whichever way you want. But these are mere averments.
These are averments. Let's me kindly have a glance at the issue number where the partition deed has been analyzed. That is issue number 1 is regarding the partition deed, and issue number 5 relates to the property under Schedule Go. All these issues have been answered in one paragraph 8 of the trial court's judgment.
Yes, sir. Tell us.
Lord, the paragraph 10 will be relevant.
10.
Yes, paragraph 10. Paragraph 10. And before that, the partition document in paragraph 9.
You read whichever you want us to read.
Lord, paragraph 9 and 10.
All right. From the aforesaid statement. Paragraph 9 begins from the aforesaid statement.
Paragraph 9 starts with the genealogy of the parties, not the trial court's judgment.
So trial court judgment.
Because the evidence has been discussed in trial court's judgment. It's a long paragraph.
Paragraph 9.
Paragraph 9.
9. The genealogy.
Genealogy. May I please it, Lord?
Yes, yes.
The genealogy of parties is admitted. Plaintiff, defendant number 1 and Nandu are the sons of second wife Pahli. Ganesh is admittedly the son through first wife of Pahli, and defendant number 6 are the heirs of Ganesh. It is admitted that Ganesh separated from the family. A suit number so-and-so got and got properties some so-and-so decimals which were given in Chaw schedule. It is also admitted that after the death of Nandu, his wife Padmavati filed a civil suit number so-and-so, and he has given so-and-so of land in compromise when she gave up her claim to the rest of the properties. In view of this admitted position, it is argued that after separation of the Ganesh, no property existed, and there was no unity of title and unity of possession. Therefore, it is argued that the presumption is available to the plaintiff that there was existence of a nucleus. The presumption that a Hindu family continues to be joint is mainly available, for the question arises whether the specific property which was admittedly joint at one time has continued to be joint, or it has ceased to be joint by virtue of separation. The conception of Hindu family consisting of a coparcenary is that of a common male ancestor with his lineal descendant in the male line. To render the property to be joint, the plaintiff must prove that family was so possessed of some property with the income of which the properties purchased would have been acquired, or from the presumption could be or from which the presumption could be drawn that all the properties purchased by the family is joint family property, where it is established or admitted that family possessed some joint property from which forms its nature and relative value may have formed the nucleus from which the properties question may have been acquired. The presumption arises that it was joint property, and the burden lies to burden shifts to the burden shifts to the party alleging self-acquisitions to establish affirmatively that the presumption that the property was acquired without aid of the joint family. But no such presumption would arise if the nucleus is such that with its help the property claimed to be joint could not have been acquired. An important element of the consideration is the income which the nucleus yielded. It is to be seen that the family had as a result of the nucleus sufficient surplus income from which the subsequent acquisition could be made. Defendants relied on a decision reported in so in which his lordships had led that there is no presumption that the Hindu family, merely because it is joint, possesses any joint property. Hindu law doesn't prohibit a member of the joint family from acquiring any property for his own benefit. The burden of proving that any particular property is joint preliminarily rests on the party who alleges the same. But where it is established that there was a nucleus of joint family property, and that nucleus was such as it did or might have constituted to the property, contributed to the property claimed to be self-acquired, the owner shifts to the person who claims the property as self-acquired. Proposition number. Yes, after discussing the evidences, comes to a conclusion that the onus of proving the property to be self-acquisition has been proving.
Evidence led to show the self-acquired. What is the evidence led to show the self-acquired?
The entire evidence has been discussed because the exhibit A. It will come. Yes, this paragraph will continue and after. The sentence beginning, after that, where I'm reading, the proposition of law has been enunciated. His lordships, then referring to 1969 Supreme Court has been referred to. Then thereafter, therefore, after separation of the Ganesh by yes. Yes. On the other hand, it appears that from the evidence of DW1, defendant number 7, that his grandfather, so-and-so, Beva, gifted such and such decimals to the mother, and his ancestral and his maternal grandfather purchased lot number so-and-so of Gausidul in the name of his father.
In the name of the father.
In the name of his father. Exhibit A is the gift deed, not that which has been referred to in the pleadings. Executed by Niasi in
favor of must be.
Yes, it must be in favor of.
In favor of
Apana. And exhibit A by 2 is the gift deed that is so executed by Apana in favor of Rukmini, the wife of defendant number 1. In view of this sort of evidence of the plaintiffs, it can be said that
It cannot be said, sir. It cannot be said.
It cannot be said. I stand corrected now. It cannot be said that there was nucleus from out of which the acquisitions are made by the joint family in the name of defendant number 1. On the other hand, the evidence of DW1 is that the income was not sufficient for the maintenance of the large family. It is also in the evidence of DW5, who was a punch member in the partition deed, that is that 25 to 30 years back, the parties were poor, and 1 or 2 years before the partition, the family was in an affluent condition. In spite of the claim by defendant number 1 that he acquired several items of property in Gausidul from out of his own income from the lands gifted to his wife, and some lands were purchased by Niasi in the name of his sons from out of their separate income. He claims to have given 8 acres of land in the partition which I was referring, Lord, in the readings, made by the Bhadraloks at their request. Therefore, the validity of the validity or otherwise of the registered partition deed, which is in existence, marked Exhibit N, is very important in this case. It appears from then paragraph 10. It appears from the evidence of DW1, who was no doubt very young when this partition took place, that Bhadralok sat for partition made chitta and over one such chitta to the plaintiff.
And made over one such chitta.
Yes, there is some omission. Made over one such chitta to the plaintiff, as well as defendant number 1. DW2 is the agnatic uncle of the plaintiff, as well as the defendant number 1, a common relation, and according to him, they were living separately since last 16 to 17 years after partition of their movable and immovable properties. He was one of the Bhadralok from out of the 5 to 6 Bhadraloks named, and he says that defendant number 1 was given 9.5 manas. The corresponding figure has been given in excess to the plaintiff, and the defendant number 1 claimed the properties made. Claimed the purchased the properties as his own, purchased lands as his own, and did not want to give, but they persuaded him to agree for this division of 9 manas and 7 anas, a basis to which the plaintiff agreed. He further states that the movable properties were divided and half between them, and the time of the said partition. At the time of the partition, also 1 year after which the partition deed was executed, he had gone to the sub-registrar office. The Mohri prepared that draft, prepared the draft. So, seeing the allotment papers prepared in the village, scribed the deed after the chitta draft was read over to the plaintiff and the defendant number 1, who admitted the contents thereof. He also states that the scribe read over the contents to the plaintiff and defendant number 1 in his presence. They admitted the contents. The defendant number 1 was signed, and the plaintiff put his LTI in his presence. He also identified them before the sub-registrar. He also states that the Bhadraloks prepared the chitta, read over, and explained them that they gave one such chitta to each of them. 9 manas of land were kept joint, and all the rest lands including the lands purchased in the name of the defendant number 1 were partitioned. Some para lands in village Dakshina Prarajpur and Mallipal were kept joint. I do not find any reason to disbelieve the evidence of this disinterested witness, who is a common relation of the parties. DW5 was also a punch who states that they divided all the 9 anas and 7 anas basis, as defendant number 1 claimed the lands gifted to his wife, purchased in his name by his father-in-law, and it is for the reason they divided unequally, so to which the plaintiff and defendant number 1 agreed. Although the plaintiff claimed in the plaint, and as well as in his chief examination, that he did not know of any such registration partition deed till 1973, he has admitted in his cross-examination that he was taken by his brother to the sub-registrar's office. The sub-registrar asked his brother if they executed the partition deed, to which his brother admitted, whom he and his brother were present though he claims to have objected before the sub-registrar that he did not execute any partition deed. It is difficult to believe when he states that he had objected. In spite of this, he did not report about the execution of the partition deed to any Bhadralok of the village. He further admits that 2 days after he came before the sub-registrar, he demanded the deed from his brother, and he did not give it. He suspected. He also admitted that he took a copy of the partition deed 8 days after he came to sub-registrar, got a copy of the deed, got it read in the village, and was told as to how unequal division has been made, but at the same time admitted to have kept quiet. Therefore, it is clear that his evidence, clear from his evidence, that the partition deed was executed and registered. He had knowledge of the same. His evidence in court that he came to know about it in the year 1970 is not true. The evidence of DW1 read together with the evidence of other logs, DWs 1 and 5, is clear that a partition took place in the in their presence between the plaintiff and the defendant number one, and 1 year after this the partition deed exhibit N was executed and registered. Therefore, in spite of the claim of the defendant number one that gauge schedule properties were the self-acquisitions, there has been a partition since the year 1961, and a registered partition deed was executed between them, in which about 8 acres from out of the lands purchased in the name of defendant number one was given. Was given by defendant number one to the plaintiff. Therefore, it is to be held that there was a previous partition, and the registered partition deed that so is neither fraudulent or illegal. That means, apart from the fact that they have the defendant number one has proved that there is no sufficient nucleus to purchase the property of joint family property, the properties which have been acquired independently by the defendant number one were also the subject matter partition in Exhibit N. And out of the same purchased properties of defendant number one, some extent of property was given to the plaintiff. Therefore, subsequent to that, after accepting the partition, he again coming forward and claiming that the properties which were left out of my joint family, out of my self-acquisition, will again be partitioned. So that is the, therefore, what I submit, that the Exhibit N, the document of partition, has been accepted to be valid by the learned trial court, by the Honorable Single Judge also. The property under defendant number one, the schedule Go purchased by the defendant number one has accepted to be self-acquired property by the learned trial court as well as by the Honorable Single Judge concurrently. Therefore, there is no scope of any interference in the present AHO. And the properties under Schedule Go of Exhibit N, because there are 2 Schedule Go properties, Go of the plaintiff and Go of Schedule N.
He's talking of Schedule N.
Yes, that is. Go of Schedule N is left joint. There is I have also no objection for that.
Oh, I see.
Go of Schedule N is joint.
The first appeal was dismissed and the entire decree was set aside.
Anyway, that may be clarified. I don't dispute there. I don't have any dispute so far as the properties covered under Schedule Go of the N.
Then if he's agreeing, then why don't we put down an agreement and be done with it? He was only talking of Ga and Schedule N, nothing else.
No, my friend is challenging the exhibit, the properties under Schedule Go of the plaintiff also. That is the difficulty.
The correction he wanted, why filed a recall, was he was not heard to the extent that the Go schedule should be Go schedule in Exhibit N.
That may be
4 acres or not. That is the preliminary decree of the trial court.
That may be just.
And 13 acres has been given to me, 18 acres has been given to you. But so far as the self-acquired property Go schedule, that was put to challenge before the trial court.
No, are you still maintaining it? You still want it?
Yes, yes. Because that is 46 acres. It's not 5-10 acres.
So in view of this.
And because major portion of the agriculture, they're all agriculturists, cultivators. Till now, they remain to be such. So now being cultivators, if more than means it is not even 20%. 46 acres he has taken.
But if he's got it through gift deeds, how can you say
no,
that?
Gift deeds thereafter. After gift deeds, everything is gone. Because if he says, the whole idea is that law is that once he says that I am the Karta, I am in charge, then he should have come as a witness and showed to the court. How did the court know? It is the DW1. DW1 is the son. He was only 15 years old at the time of partition. How can the trial court rely upon such a testimony itself? And he has been examined after 16 years.
Okay. All right.
So that's all about.
All right. Orders reserved.
Orders.
Yes.
Weekly list, leftover list. Item number 1, WPC 8139 of 2007.
Item number 1, Lordship, I pray Passover for the day, Lordship.
My lord, last 3 weeks they have passed over the matter, but not taken.
Lordship, my learning is on the part hard matter is going on. Pray for Passover, Lordship. On behalf of Mr. Mishra.
We're just passing over this matter. Or,
Lordship.
all right.
Item number 2.
May it please the petitioner is a lady entrepreneur and has challenged the order passed by the opposite parties asking the so-called, and thereafter they have decided to cancel the petrol outlet, my lord. Your lordship can have a look to the impugned order. That is annexure 1 at running page 12. Prior to that, my lords may have a look to annexure 2, wherein at page 16, selection for case operation of operationship of location Boltra, district Boltra. Dear madam, this is further to be interview held on 8/6/2006 and subsequent complaint dated 9/6/96 after investigation of the complaint and the reassessment of the marks, Srimati Rajeshwari Patel has been declared as the first independent candidate. The statement of performance of the candidates after re-evaluation of the marks of the etc. This is dated 15/12/2006. Thereafter, my lord, in annexure 3 at page, this was on 15/12/2006, then on 12/2/2009. A communication was made to me. We take this opportunity to welcome you to Indian Oil family and further to our etc. We are pleased to appoint you as our Kisan Seva Kendra operator of Bhukta partnership, that is Paiko, that is Prabha, District Bargarh, on the terms and conditions contained in the dealership agreement. 3 copies, etc. Accordingly, the agreement was made and I continued the dealership. While I was so continuing, you also can have a look to annexure 5 at page 49.
Milord, may I intervene for a moment? It's an appealable order, and both are arbitrable and appealable. It's Milord, without availing that remedy, he has straightway come to record. Page 15, Milord, the last paragraph, the impugned order itself says that it's within 30 days you can prefer an appeal. Lots of disputed questions of fact.
Without giving without causing any inquiry, the order has been passed, and that is under challenge here, my lord. Otherwise, they're going to appreciating that your lordship have passed an interim order, so that the dealership will not be cancelled.
Mr. Acharya,
man,
would it not be better that since there's a status quo order in this favor, we permit you to hold a whole inquiry and complete it in a time-bound manner?
Lord, that's correct, your lordship. That is what exactly I am submitting. Lord, page 15, your lordship, that opportunity was given to him. Page 15, the last paragraph. It may please be noted that as per clause, Lord, the impugned order itself, Lord, clause Roman 4 of the notes under chapter 6 of the
appeal
MDP.
is different, sir. Appeal is different. I'm saying his point is preceding the findings that you have set out in your order, there was no inquiry as such.
No, Lord, there was comprehensive inquiry. He was given ample opportunity. His so-cause, our so-cause, his reply, then re-reply, everything, all the formalities were completed, Milord. Not that it's an order, yes. Milord, everything he has annexed, Milord, we have also filed a detailed counter. But to make it short and to save your lordship's time, it is both appealable and arbitrable too. My lord, you will
I
accept
have
me?
filed
Yes.
There
is an arbitration clause under clause 62 as page 42, my lord. Any dispute or difference of any nature which is to be, my lord, decided not, my lord, by an officer not below the rank of a director of marketing. And appeal also lies to the executive director, the highest authority of the corporation. That he can avail, because since lots of disputed, my lord, show cause was given, he has given his reply, and my lord, everything has been considered. It's a speaking order, 4-page order, running from page 12 to 15. Each, my lord, allegation wise, it has been dealt with. I don't think, my lord, if you lordships.
I've given detailed rejoinder, my lords, as suggested. Keeping the status quo, I may be allowed to appear. I have no difficulty in that.
Or if say the admitted position is the order dated 15th March 2012, passed by Indian Oil Corporation Limited, which has been challenged by the present petitioner in the present petition, is appealable before the Executive Director of Indian Oil Corporation Limited, bracket IOCL. In that view of the matter, counsel for the petitioner states that he will withdraw this writ petition with liberty to file an appeal before the ED IOCL. Full stop. If such appeal is filed before the ED IOCL not later than 15th March 2023, then the delay in filing such appeal, if any, will stand condoned on account of the pendency of the present writ petition. Paragraph. After giving notice to the petitioner in the appeal and fixing a date of hearing, which will be intimated to the petitioner at least 10 days in advance, the ED will pass an appropriate reasoned order in the appeal within a further period of 4 months thereafter. We'll stop till such, and that order will be communicated to the petitioner within a week of it being passed. We'll stop till such time the status quo order passed by this court on.
My lord, I passed that order on
3rd April 2012 will continue.
Yes.
The court clarifies it has not expressed any view on the matter.
Obliged by.
Obliged. Deeply obliged.
Item number 3.
My lord, appearing for the opposite party, ITCO, my lord, I pray seek an adjournment, my lord, in this matter. Senior.
For what?
My lord, Mr. Patnaik will appear in this matter, and we have to take some instructions regarding the present status of the land over which this litigation has aroused, my lord. Whether the land is vacant or it has been one of the parties in over that land for setting up a new industry, my lord. So whether the matter is still subsisting, whether the merits are still subsisting, we have to take instructions on that count.
What are your instructions, Nanda?
Lord, there has been no development so far as that particular land is concerned.
So there's a stay order here. I don't know
Yes,
how they
ma'am.
can.
That's in my favor.
Yes.
Your lordship, this is the second round of litigation. I've given a small 2-page note if your lordships may just.
No,
have
but
a-
if he wants, it will be the main contesting party.
Yes, ma'am. So if he wants some time to bring on record anything, I have absolutely no objection to that. But your lordships can keep it to whatever the shortest time possible, then the matter can be heard.
So we'll call it next Monday then, not to be called till next Monday. What?
Next Monday.
Item number 4.
Grateful.
Item 4, I am for the opposite party workmen. Lordship, on behalf of learned senior advocate Narendra Kishore Mishra, I seek for a pass away, Lordship. He had to leave because of his ill health.
Awesome.
Item number 5.
Much of next day. Lordship, pass for the next day.
Item number 5.
I'm filing an affidavit. Actually, I'm filing an affidavit. The state government has taken a policy decision. Your lordship, the policy decision I am submitting to your lordship. And before that, your lordship may kindly have a glance to the Order number 7 dated 16/3/2018, passed by your lordship. Order number 7 dated 16/3/2018. Learned additional government advocate submits that she does not have the copy of the regional so and so. The learned counsel for the petition submit that the state government has taken a specific plea at paragraph 7 of the counter affidavit as follows. That in reply to the affirmations made in so and so paragraph 12 and 10 and 10 to 12, the writ petition, it is most respectfully submitted that they admitted that the PIO of Land Department had in fact intimated to the petitioner that the concerned allotment file bearing number so and so has been processed for obtaining the orders to supply the lease deed by copy of the letter annexed as Annexure 6 to the writ petition. Of late, the department have formulated a policy to deal with such irregular cases, and a policy decision in this regard is being awaited. Unless the policy decision is arrived at, it will not be possible on the part of the opposite party to entertain the prayer of the petitioner. Then, your lordship, the policy decision taken by the state, I have annexed as Annexure.
Mr. Mohanty, you will consider his case under the policy.
My lord, actually, day before yesterday, I had given a letter to the director seeking 3 queries. One is status of the land in question, if it is leased out in favor of any third party. Number 2 is current market value of the land in question. And number 3, whether the department has formulated the policy yet. Now he is showing a policy of 2013. Whether that has been superseded or not, that also I
It's
do not know.
superseded in terms of superseded policy.
Yes.
Your lordship may direct that considering the existing policy
Counsel for the petitioner has filed.
and the current market value also.
Whatever, so the policy will take care of all that. Counsel for the petitioner has filed an affidavit enclosing copy of an order dated 19 December 2013, issued by the General Administration Department, Government of Orissa, setting out the policy of the government in relation to regularization of the cases of parties who had been allotted land but could not execute lease deeds, but in whose favor lease deeds could not be executed for a variety of reasons. Paragraph. In that view of the matter, a direction is issued to the GA department to process the case of the present petitioner in terms of the said policy or in terms of any subsequent policy that may have superseded the said policy. And after giving hearing to the petitioner, to pass appropriate orders in the case of the petitioner in terms of such policy. Full stop. The date of hearing of the petitioner should be intimated at least 10 days in advance to the petitioner. Full stop. The order thereon be passed after hearing the petitioner within a period of 4 months thereafter. Full stop. The order be communicated to the petitioner within a week of being passed. Till such time, the status quo as of today shall be maintained. The court clarifies it has not expressed any view in the matter.
Item number 6.
May I please, my lord? My lord, kindly have a glance to the last order, my lord, on 4/8/2014.
Who's for the other side?
Endowment Commissioner, I think. Commissioner of Endowment.
No counter also been filed.
No, the main contesting party is opposite party number 3.
Sorry, I have not copied.
No. Opposite party number 3 is some Dukhi Shyam Behra. The impugned order was passed in his favor and that got stayed by you. And who's appearing for him? He's appearing for the commissioner.
He is Mr. Nath.
No, but who's appearing for that contesting opposite party number 3? Was he served at all?
Please don't ask.
He's not even filed a reply. Nobody's filed a reply. All right. The petitioner had filed a present petition challenging an order dated 2nd July 2014 passed by the Assistant Commissioner of Endowments, authorizing the Inspector of Endowments, Sakhi Gopal, to put the opposite party number 3, Dukisha Behra, described as managing trustee, in possession of the Temple of Sri Gobinju Vijay Bali Sahib, Gobinju Patna, as well as its properties. And report execution of the said order by 31st July 2014. Paragraph. While issuing notice in the present petition, on 4th August 2014, this court stayed the operation of the said order. Full stop. That interim order is continued till date. Paragraph. It must be noticed at the outset that despite service of notice upon opposite party number 3, none has appeared on his behalf to contest the present petition. The case of the petitioners that in separate proceedings under section 41 of the OHRE Act, in OA number 53 of 36, 53 by 36 of 1970, the deity in question has been declared to be a private deity, and the properties belonging to the deity have been declared to be private endowments. It was pointed out that earlier similar orders passed in favor of opposite party number 3 were already challenged in separate petitions in this court, and their operation has already been stayed by the court. Full stop. The third factor is that under section 7 of the OHRE Act, the commissioner has appointed a fresh trust board with effect from 28th November 2013. Paragraph. Inasmuch as there is no counter affidavit filed by any of the parties to contradict any of the above amendments, this court sets aside the impugned order dated 2nd July 2014. It is clarified that this order will not affect the outcome of any of the other proceedings concerning the temple in question, either pending before the commissioner or this court. Full stop. The writ petition is disposed of in the above terms.
Item number 7. Item number 8.
Item 8, my lords, is that Javan's case, my lords, where they had to file the substitution application. Because the original petitioner had come through the power of attorney holder, and the petitioner has deceased. So,
who's for the petitioner? Which matter are you in?
My lord, nine, my lord, nine.
I see.
Item
None
8.
None appears for the petition. Dismissed for non-prosecution. The contempt case, you say, none appears, dismissed for non-prosecution. All right.
Item 9.
Please, your lordship. My lord, in this writ application, I am challenging the decision of the Deputy Collector Puri, wherein he has decided that the land which was leased in favor of my seller be resumed and the Tahsildar take possession of the land. Lordship, may kindly see the list of dates.
May I submit one thing, my lord? My lord, this is an order sheet he has challenged. Deputy collector has sent the file to the it will be sent to the collector. Collector will take the final decision. At a premature stage, he has come to court. Let the director be let the collector be directed to take a final decision. Collector may accept the view of the deputy collector, may not accept the view of the
page 47, my lord.
Yes,
Page 47 may kindly see, my lord.
Page 47 is the order of the deputy collector.
Here the collector has said, take steps for determination of the lease as per provision of law. At the bottom, my lord, page 47. I apologize for my voice, my lord. Page 47, bottom, my lord, 3 lines. Take steps for determination of the lease as per provision of law. So decision has already been taken, my lord.
No, for resumption. For
resumption.
There is no.
No, when he says take steps, it doesn't mean that he has decided it.
My lord, take steps for determination of the lease as per provision of law, my lord.
That's what as per provision means. It's not a final view.
Let the collector then decide, your lordship may say.
The challenge in the present petition.
And my lord,
is to an
status quo was there.
Status quo will continue.
Order dated. Order is dated 26th April and 1st May 2013 of the Deputy Collector Puri, bracket opposite party number 3, whereby the matter has been placed, matter concerning cancellation of the lease issued in favor of
vendor of the
present petitioner.
Petitioner number 2 and 3, my lord.
Petitioners 2 and 3.
As 3, 4, my lord. They are legal heirs of the present title holder.
Petitioner number 1.
No, my lord. Vendor of petitioner number 2, 3, and 4, my lord. It was subsequently it was sold to the father of petitioner number 2, 3, and 4, my lord. So in the meantime, in 2018, the
in favor of petitioners 2, 3, and 4 has been asked to be placed before the collector for a final decision. Paragraph. At the outset, Mr. D.K. Manti, learned counsel appearing for the AGA, appearing for the state, informs the court that the final call in regard to cancellation of the lease would have to be taken only by the collector, who may or may not agree with the recommendation of the deputy collector. And therefore, the present petition should be considered to be premature. For stop, he adds that a time-bound direction could be given to the collector to hear the present petitioners as well as the state and pass appropriate orders in accordance with law. Paragraph. In that view of the matter, it is directed that the collector will now proceed in the matter in terms of the impugned order of the deputy collector. And after hearing the parties, that is including the present petitioners, on a date to be informed to them at least 10 days in advance, pass a reasoned order within a further period of 4 months and communicate the order to the parties within a week thereafter. Till such time, the status quo as of today shall be maintained. The petition is disposed of. The clerk clarifies it is not expressed anywhere in the matter.
Item number 10.
May it please your lordship.
I'm filing a.
This is only for conversion from leasehold to freehold.
My lord.
Ah,
No, they have charged on two grounds, two counts. One is for conversion, another is for
differential premium.
my lord.
Yeah.
But they have not been giving true facts before this honorable court. That is what I have submitted. So let them file a comprehensive counter so that I can apply.
No. Where is the property in Bhubaneswar?
In Bhubaneswar.
Ah, what's the current market value?
Let them say so. How they have
You don't know, sir? Are you seriously telling us you don't know the current market value of your property?
Naturally, we don't know.
You don't know?
I don't know.
I see. Should we record that you don't know the current market value?
I don't know.
I see. You're able to assert that. Without knowing the value of the property, you're occupying it.
No. It has been leased to my. It was leased in favor of Lal Bihari Das. After his death, they sought mutation. Mutation was allowed, and then the land was recorded in favor of the petitioner. Then they applied for.
Petitioner meaning what? How are you related to Lal Bihari Das?
We are the legal heirs.
Legal. All right.
Wife and sons.
All right. What is the extent of the property?
This is in Bapuji Nagar, my lord, heart of the Bhubaneswar.
No. What is the extent?
The extent is
75 into
60 feet. 75 into 60.
Our objection in respect to the differential premium.
What is the? You're not telling us what your current market value is, and you're arguing. You have your residential property there.
My lord.
Are you still occupying it?
Yes, we are in occupation.
That for conversion of the land, certain charges have to be imposed on them.
Correct.
We have to recover those charges. They are saying
Correct.
that we are entitled to certain concessional rate, and our counter affidavit is that they are not entitled to this
concession.
That annexure A/1 is the notification. That the GA department notification is at page 12 of my counter affidavit, annexure A/1.
Lordship, may kindly.
What you're not conveying to us is you're running a furniture go down called Bharat Furniture.
Lordship, may kindly see.
Ah.
First, your Lordship, may kindly see first rejoinder filed by me, page 2. Rejoinder to their counter at page 2 may kindly be seen. They have given these benefits that I have been claiming in respect to 5 plots that I have mentioned.
There's nothing. We don't interfere with.
Your Lordship, may kindly see the rejoinder submitted by me, first rejoinder.
See, in a writ petition, we can't interfere with what premium rate should be fixed and all.
No, they cannot.
If you have to pay, you have to pay.
My lord, can they discriminate? Let them say on what basis they have decided that amount.
Yes.
And I have clearly said that they have given the benefit as I have been claiming in respect to plot number 97, 101, 83, 94, and 85 at page 2 of my first rejoinder.
Yes.
They must say that they cannot discriminate.
First of all, you violated the conditions of allotment. You're using it for a commercial purpose.
No, for commercial.
Yes.
So there is a rate. I'm for commercial purpose. Even if I use for commercial purpose, there is a particular rate. They don't deny.
Yes.
Your Lordship may kindly see.
Yes.
Para
paying
13
nothing.
of the counter affidavit.
Actually, the problem is we passed unconditional stay orders.
They have said that.
Para 13 of my
Yeah,
counter
he's
affidavit,
using
page 8.
Now he is converted to receipt shop.
They have different rates for commercial purpose also.
Correct, correct.
Your Lordship, may kindly look at page 29 of the read petition. There is a rate for commercial purpose also. I don't dispute that, but let them say on what, how they have come determine the rate. Even if I use for commercial, there will be a rate for it.
There's a proper shop here. Nimapada Sweets.
First, they made a false submission that it was on the main road. And now they say, Your Lordship will kindly see page 7 of the last reply submitted by them. They refer to some other case. Their report is based on some other case which I have never filed.
Photographs are there.
No, page 7 the last जो reply दीजिए तार page 7 देखो तो से आगे को read petition रो ये question. They refer to that inquiry has been made in respect to WPC number 133 of 1997, which I never filed. And in 1997, the nomenclature was not WPC. So all along they have been filing, making submissions, not based on facts.
The last affidavit was filed on 3rd January 2020. That is our affidavit. No, this 3rd January is the last affidavit filed on behalf of the.
So how much have you paid since the day you filed the writ petition? How much amount have you paid?
No, I have submitted that the conversion fee I am prepared to pay.
Sorry?
Conversion fee. Conversion fee, whatever they have demanded, I am prepared to pay.
No. You are very generous. He's saying you're prepared.
Not generous.
No, 1 minute. Let's come to page 12. Come to page 12.
Page 12 of the read petition.
Yes.
My lord.
How much have you to pay for conversion?
18 lakhs.
When did you pay it?
I have not paid it.
Why not? You seem to argue as a which you have every right not to pay.
No.
What is this kind of arguing also? I'm not understanding. The last 10 minutes of watching, you're coming to the court saying as if you can do whatever you like.
No, certainly
under
not.
the sun.
Certainly not.
You no questions
I have
can be
never
asked
made
of
such
you.
a submission.
What is this kind of an
I have
attitude?
never made such a submission.
What is this kind of an attitude?
No, I have never made such a submission. And your lordship.
When did you pay this 18 lakhs?
And your lordship.
When did you pay this 18 lakhs, sir? When did you pay this 18 lakhs?
I have never paid that. They have rejected my application. Thereafter I came.
What application they rejected?
My
Did you offer 18 lakhs and they rejected 18 lakhs?
18 lakhs. I have all along been saying that yes, I am prepared.
You are saying is, did you tender this 18 lakhs to them?
No.
You did not.
No.
This is 29/5/2014, correct?
No.
And we are in 2023.
Yes.
For 9 years without paying 18 lakhs, which admittedly you want to pay, you're just enjoying.
No. Otherwise, I will be enjoying this. My lord, since it is a leasehold
It's all misuse of proceedings, sir. Complete misuse.
We are only applying.
This is abuse of the process of law. I'm sorry to say.
Certainly not.
Yes.
Your lordship must say so.
Yes.
But it is not a fact.
Yes. It's not a fact. It's law, sir.
My lord,
the fact is what you're telling us. That you're without paying a penny, you're enjoying property despite knowing you are supposed to pay 18 lakhs.
Not gone through and you're not allowing me to make my submission. It is a 90-year lease case. So leasehold property I am entitled to enjoy. Only thing is whether it can be converted to freehold or not.
You first pay this 18 lakhs. How soon can you pay? No, let's get over something. You're admitting you have to pay 18 lakhs.
Yes.
First,
No.
First pay. Sir, this is 226.
Just a minute, Your Lordship, allow me to say something. That Your Lordship is not allowing. It is a 90-year lease case. So we can lease as we can enjoy the land as such.
I see.
Without paying anything.
I see.
Now when
this is new law.
No, sir,
This
he
is new
cannot
law.
enjoy like this unless the land is
No.
converted.
This is if
we
you
will
say,
resume the property.
If you say something, he will say he's not being allowed.
Cancel the lease.
He makes these outlandish submissions. Sir, continue saying. Continue
Your
saying.
Lordship may kindly see.
Please say, sir. It's very
agreement-
interesting. Hearing you saying is very interesting. Continue saying. Very interesting what you're saying.
Your Lordship may kindly turn to page 22, my Lord will say.
Yes, yes.
ପଟ୍ଟାର ମିଆଦ 14/5/58 ଠାରୁ 90 ବର୍ଷ ପର୍ଯ୍ୟନ୍ତ.
I see.
It will last till 90 years.
I
The
see.
lease is given to me for 90 years.
No condition.
Once I pray for conversion or to freehold, thereafter I will pay all these things.
Sir, we don't want to stop you. Very interesting submissions you're making. Continue making them.
The lease is for 90 years. So we can continue there as such. Our application is only for changing it to freehold land. And for that purpose, they have demanded two amounts. Conversion fee, yes, we say that yes, we will pay. But we are contesting the amount determined in relation to freehold, that premium, differential premium.
You finished, sir?
Yes, sir.
My lord, I will only take 2 minutes. My last affidavit filed on 3rd January 2023, page 3, paragraph 5, 3rd January 2023. That it is humbly submitted that from the above said inquiry report, it is revealed that over the suit leasehold plot number 80, drawing number so RCC roof buildings exist and both are being used for commercial purposes, that is Nimapada Suites, New Lifestyle, Fast Fly, etc., which violates the lease condition number 2 of the lease deed dated. So the conversion is not only for the process of acquiring Sthitivan right. That is required for him because he is violating the lease condition. He has to convert it for commercial purpose. Then only he will continue the land for occupation on account of this lease condition. There is a lease condition that unless you convert it to the commercial purpose, you cannot continue the possession. Otherwise, the lease will be cancelled for violation of the lease condition. That is why he has applied. And we can allow the conversion, but subject to two demands, that is conversion fees and differential cost. He is saying that I will pay only conversion fees, differential cost I will not pay. But the scheme of the GA department, the notification which I have filed under Annexure A/3, that is applicable to all. Everybody is paying in Bapuji Nagar. That is a very commercial place. Everybody is, while allowing the conversion, we recover this amount from all the lessees. Then only they will be conferred with Stitivan right. And they can use the land for any purpose, commercial purpose, whatever the purpose may be.
Lordship, may kindly turn to page 29 of my brief. Read petition. For commercial purpose also they have a rate.
That is what
So
we
what
have
my
charged.
learned friend is submitting is not correct. I am relying on their document.
Anything else, sir?
That's
How does the result?
Item number 11.
Your notices were issued earlier. The state has not filed its counter. This, we are challenging the order under Annexure 1, which is the order of the ADM. So this is not covered by Narottam Dutt's case, but we would request that he may be granted the Patta Mellots. We have raised 5 grounds under ground number C. There are 5 grounds. First ground is that after remand by this court, the remand order is under Annexure 2. The ADM who heard the matter didn't pass the order, or ADM was changed. So that factual thing, that is our first
That can
point.
be a ground for again remanding the matter. If the person concerned who has heard the matter, he has not passed the order.
That's our, I just submitted that they didn't, you have not filed your counter. This is one ground. The other grounds are that now they are saying that 3B violations have come in. In the cancellation order, that was not a ground. So new grounds have now come in.
All right. This is the second round of litigation concerning revision case number 723 of 1987, initiated by the Additional District Magistrate Bhubaneswar under Section 7 capital A bracket 3 of the OGLS Act. Stop. In the first round, the petitioners had filed a petition civil 9268 of 2011, which was disposed of with this court on 10th February 2012, remanding revision case number 723 of 1987 to the file of the ADM for a fresh hearing and for passing an order afresh after hearing the parties. Paragraph. One of the grounds raised in the present petition, which challenges the fresh order passed on 12th January 2015 by the ADM Bhubaneswar in the aforementioned revision case, is that the person holding the post of ADM Bhubaneswar who heard the parties was not the same person who finally passed the impugned order dated 12th January 2015. Paragraph. Despite this writ petition having been filed in 2015 and notice having been issued way back on 29th October 2015, till date, no counter affidavit has been filed to contradict any of the above averments. Full stop. A second averment is that in passing the impugned order, a new ground has been pointed out that the original conditions of lease have been violated, thereby attracting Section 3 capital B of the OGLS Act, whereas at the time when the matter was remanded by this court, there was no such ground put forth on behalf of the opposite party state. Paragraph. As already noticed, since no counter affidavit has been filed to contradict any of the above averments, the court proceeds on the basis that the impugned order was passed by the person who did not himself hear the parties in the aforementioned revision case. Full stop. On that short ground, the impugned order dated 12th January 2015 is hereby set aside and revision case number 723 of 1987 is again remanded to the file of the ADM Bhubaneswar, where it will be listed for directions on 15th March 2023. Full stop. On that date, the petitioner will appear along with a downloaded copy of this order. Full stop. After hearing the petitioner and other parties, the ADM will pass a fresh order in accordance with law within a period of 4 months thereafter. The order be communicated to the parties within a week of being passed. Full stop. Till such time, the interim order passed with this court on 29th October 2015 will continue.
Yeah, great.
The petition is disposed.
Item number 12.
Item number 12, may I please, Your Lordship? I'm appearing through VC, my lord. The petitioner company has challenged the order dated 16/4/2015, my lord, passed by the presiding officer, Labour Court, Bhubaneswar, where the Labour Court has directed that the opposite party number 2 and 3 are entitled to receive an amount of rupees of the back wages, my lord, under 17B for the period from 7/10/2009 to 2013. But the workmen, as opposite party number 2 and 3, has filed their case before the industrial tribunal, alleging the illegal termination from services, and the direction was given by the opposite party number 1 that they will be reinstated in service with full back wages. But my lord, the management has challenged the award dated 7/7/2012 passed by the learned industrial tribunal, and on which basis ID miss case was filed by the opposite party number 2 and 3, directing the which is in item number 2, my lord, WPC number 19114 of 2012, where the award has been challenged, and we have challenged the ID miss case number for the computation of the award, my lord.
Yes.
But I'm from the opposite party. In the earlier occasion, your lordship is directed to file and calculations. We have filed the calculations.
Lord, I have not got that calculation sheet, but my lord, they have not filed an affidavit which is provided under section 17B of the ID.
How much have you paid them so far?
No, had not been paid, my lord. I pray that let the matter be referred to local Adalat, as to which my lord directed to file the calculation.
What according to you have to pay? You tell us that.
17B.
What amount are you admitting that you have to pay? What is your admitted amount that you have to pay?
Yes, my lord. 3 lakhs for opposite party number 2, 3,02,601 rupees, and for opposite party number 3, 2,53,951 rupees.
This you are agreeing to pay?
Only the back wages, my lord.
No, you are agreeing to pay these two amounts?
Yes, my lord. Yes, my lord.
When will you deposit these two amounts? When will you pay them these two amounts? Then we'll send you to Lok Adalat.
Yes, my lord. Oh, yes, my lord.
When will you pay them?
1 month time may be given, my lord.
All right. The counsel for the petitioner states that within 4 weeks from today, the petitioner will pay opposite party number 2 the sum of rupees 3,02,601. What's the exact amount?
3,02,601.
601, and opposite party number 3, 2,53,951, without prejudice to the rights and contentions in this petition. Stop. Counsel appearing for opposite parties 2 and 3 states that they will receive those respective amounts again without prejudice to the rights and contentions. Full stop. For reporting compliance with the above assurance, list on.
My lord, if I will pay that man, then the matter will be over.
That is up to you. 2nd March 2023.
Well, our name has not been reflected, though we have filed and booklet on 24/1/2023.
list in the regular list on 2nd March 2023. The question of referring the parties to Lok Adalat will be addressed subject to compliance with the above direction. Right.
Item number 13. Item number 13.
None appears dismissed.
Lord, in 13, I am for the respondent number 2. Just try to note the appearance. Oblige. Item number 14.
My lord, in this case, my name appears for opposite party, but this by orders of this honorable court. But neither I am intimated nor my client is intimated regarding this order. We don't know the order. Today I have seen from the order sheet. I have seen that.
All right. You are for the petitioner.
I'm for the petition.
What's the matter about?
Matter is about, it can be disposed of. Matter is about the notice. The bank, the cooperative bank, his license was seized, my lord, for banking operation. Thereafter, a publication in the paper for realization of attachment of the property. So that was impugned, challenged in this writ application. What I suggest, my lord, now the winding up proceeding has been initiated. The official liquidator has been appointed. Your lordship may kindly come to annex.
So then, why it is infructuous then?
Your lordship just observe that we approach
in view of the subsequent developments where the respondent bank is in winding up and registrar has been appointed as
DRC, Deputy Registrar Cooperative Society.
Deputy Registrar Cooperative Society has been appointed as the
official liquidator.
Official liquidator.
Annexure 2, my lord.
All right. The present petition has been rendered infructuous. It will be open to the parties to pursue the remedies in the liquidation proceedings. Right. The petition is disposed.
My lord, one more thing, lord. By virtue of the order of this honorable court, 1 lakh of rupees has been deposited at the time of admission, my lord, before this honorable court's registry, my lord.
All right. The amount deposited in this registry, together with interest accrued thereon, will be made over by the registry to the deputy registrar or cooperative societies forthwith. All right.
For being adjusted against
obviously.
Connected matter. Both are same, but second
Both
item
same
is,
order.
Second item is in respect of a guarantor.
Yes,
Same
order.
Right.
Item 15.
May I please, my lords? My lords, the opposite party, DICO, leased out a plot for setting up an industrial unit, my lords. There was a lease deed for 99 years, my lords. Lease exists up to 2095, my lords. And the consideration amount was paid way back in 2008, my lord. Now, my lords, kindly turn to page 39. By annexure 3, my lords, a notice was issued to show cause why my lease will not be cancelled, my lords.
So these are
the grounds.
SARFACI proceedings.
My lord.
This is writ petition 15954, 14954.
14954, my lord.
So the impugned notice is under the SARFACI Act.
My lords,
Possession notice, Central Bank of India.
There must be some. My lords,
Cancellation of allotment.
impugned order at page 9, my lords.
1 minute, there's something wrong then. What's this? 2015, they've scanned 2014. It's scanned 2014.
My lords got the.
Yeah. You filed a counter in this?
Hello, we have filed counter.
Yes, sir.
My lords, kindly turn to page 39, my lords, the show cause notice, my lords.
Yes.
My lords, the first point was you have not utilized the land for the purpose for which it was allotted. You have not yet submitted NOC or from pollution board, my lords. You have not yet taken approval from competent authority for construction of the factory for allotment as per clause. Loan sanctioned letter from finance. My lords, now kindly come to page 41, my lords. My reply. Page 41. My lords, got page 41?
Yes.
My lords, we will utilize the land after getting all facilities like power, water. My lords, the infrastructure was not developed, my lords. Second is that NOC from is not required for fabrication unit, my lords. The third that please give approval for construction of factory building as well as intimate us for the further submission of documents in the matter, my lords. It was in 2011, my lords. I pointed out that the infrastructure is not developed. Even electricity was not provided. My lords, the drawings and approvals I have sought for from the authority was not given to me, my lords. Now, my lords, can we come to page 9? My lords, after 3 years, without any intimation to me, my lords, on my reply, they have passed this order after 3 years at page 9, my lords. Only, my lords, only one line is written that your explanation is not satisfactory, my lords. This is the lease for 99 years, my lords. I have paid the consideration amount. They failed to develop the area by developing the infrastructure, my lords. And they cancel this without any application of mine to my reply. And they have not given any opportunity of hearing to me, my lords, also.
So this plot is 1 acre.
My lords, for development of industry.
1 minute, sir, 1 minute. So this is in a industrial estate?
Sundargarh, my
Industrial
lords.
estate.
My lords.
So if what you say is right, there should not be a single industry in that whole industry.
My lords, the entire land was vacant, my lords. Nobody has developed anything by the time. Now it has been developed, my lords.
So suddenly water, electricity and all has come.
5 years, my lords.
No, suddenly it has come.
My 7 years.
No.
In the meantime,
see, you got a stay from us.
My
now you should have developed the whole plot.
No, my lords. What I humbly submit, my lords, by the time when I given my reply, my lords, even my lords, there was no electricity.
Sir, I'm on something else, sir.
Pardon, my lords.
Are you able to hear me, sir?
My lord.
You came to this court
my lord.
And you got a stay.
My lord.
Now there's nothing, nobody prevented you from setting up your industry there. Stay from this court. Water, electricity, according to you, is now available.
My lord.
Did you construct your industry, sir?
My lords, I am ready to construct.
Not that readiness is not. Nobody stopped you, sir.
My lords.
You can continue being ready for the next 20 years.
My lords, in 2015, status quo order was passed by this honorable court, and my lords,
yes.
And now my instruction is that now they have developed the infrastructure, and it is now we can construct, my lords. My lords, the consideration amount.
Today the matter is listed on its own. You never filed an application here saying I am ready now to construct. You never said that.
My lords, honestly speaking, I have moved once and twice. It was not listed.
No. Even now, nobody prevented you from filing an application. Listing is another thing. Listing, I will immediately tell you, the last 2 years I have been sitting here as Chief Justice. Not one day Mr. Beura mentioned this matter before me. All that I will tell you. And you will have no answer to that. But assuming that you were even earlier interested,
my lords, recently,
if you had filed an IA, have you filed an IA saying I'm interested in resuming construction on this land?
My lord, beg apology for that. I have not taken. But my rights,
Apology, sir. It's
my
not
lord,
about
my
apology.
rights,
This is
my
about
right-
what your client wants to do. Is he really bona fide? Is he interested?
my-
Or he's just holding on to plot?
No, my lord, she will construct, I'll undertake, he is pursuing me, my lords. I undertake that, my lords, will take all steps for construction within
They
6
lost a
months.
lot of premium. See, because of a stay order passed by us, this is 1 acre plot. What is the value of this 1 acre plot?
No,
sir?
no, my lords,
Industrial
it's outside the township, my lords. It was the special economic zone, my lords.
Sir, I am totally illiterate on commercial matters, sir. I can tell you that.
My lords,
No.
No,
Industrial estate in Jharsuguda, 1 acre. If you tell me it is worth 20,000, you want me to believe it?
No, my lords.
What will be the value, sir? You tell me industrial estate, Jharsuguda, 1 acre plot, what will be its value?
My lords, I have.
You are not aware.
No, I am not telling.
Totally ignorant.
My lords, kindly.
You're dealing with commercial matters. You're not aware.
Kindly. My lords, in 2008, my lords, I have paid consideration amount of 4 lakhs. In normal process, it will be not less than 50 lakhs today, my lords.
That not less than is a very nice expression, sir.
My lord, my lord, what
Not less than is a very beautiful expression.
What I humbly submit.
Let me ask somebody else in this whole court hall will know 1 acre in Jharsuguda industrial estate. How much will it be?
What I humbly submit, my lord.
So we are not, see, the problem with all of us, I'm telling you,
my lord,
is that we don't look at the economics of a situation at all. So easy to go to a court and get a stay order. And keep the stay order, sit on it for years on end.
My lord.
All these, see, on the other side also, they're not bothered. You're very happy because you got such a valuable plot which is appreciating day by day, plot is appreciating. Your client is very happy. He's got gold mine. It's like a huge investment, sir.
No, my lords, they are regularly
And the
raising.
government is not bothered. So many such lands are locked up everywhere. They are not moving the court to say, sir, valuable land is, look at his client. They never moved any application.
My lords, what I humbly submit, regularly they are raising penal interest on me without giving any facilities for utilizing the land, my lords. Your lordship, it is up to 95. Your lordship kindly.
What do you charge for this plot, sir? What do you charge for this plot? Lease is free lease. All these people seem to think everything is free. The previous council was arguing everything is free. No conditions attached. He can do anything he likes. The previous council also was arguing. This man is also saying 90-year lease, which means valuable land. If he gets, they believe they have to pay nothing. Not comply with any condition, nothing. It's as if it's been a gift given to them. What does he have to pay?
That I have to, my lord.
My lord,
refer to a show cause notice. Prior to that, also,
Sir, I'm very disappointed to note council appearing for ITCO, some development authorities have no idea of value of land, sir. How are you appearing in these matters without knowing what the ground reality is? This is not just one brief, sir. Go file counter rejoinder.
We are only
What is the value of this land? Are you aware what 1 acre in Jharsuguda today industrial estate will cost? Jharsuguda is an airport, I think.
My lord. Yes.
I'm not so ignorant, sir.
My lord.
You people do your homework. You first, let's stay on board. You first call up your client today. Sir, if I have to get an allotment of 1 acre in your industrial estate, how much do I have to pay? You ask
That
him.
I will often
First ask him. You share it with him because he is not aware, poor man. He's also not aware.
my lords, I said not less than 50 lakhs.
Not less than is a very nice expression. I told you that also.
There is clear breach of terms of the allotment. That is,
Sir,
my lord.
First understand what is the economics of the situation. What is the stay order meant to him? What is the stay order? What is the loss to you because of the stay order? Are you aware of the loss to you?
Regarding the land.
Your officers also don't calculate the loss to the corporation, to the ITCO. This is the problem. See, if you're dealing commercial matters, you should have a commercial sense. Only then you can argue. Anyway, it will stay on board.
Tomorrow, my lord.
Whatever. You find out, the earlier you find out, the better. Better for him also. He is all ready. He says his client is ready to now, tomorrow morning, put foundation stone and start.
My lord.
So
I undertake my lord.
you capture on that. So whatever he has to pay, you give him that bill or whatever, he will immediately pay and immediately start. All right. Nothing. He's got enough. All right.
Item number 16.
16. I'm filing a rejoinder today. That is the case where the petitioner's land was forcibly taken away by the government in 1961, and they constructed a primary health center over it. Thereafter, my lords, the suit was filed.
Before my learned senior argues, because inadvertently, the file has been misplaced, my lords. Let it come tomorrow, my lords. Let's stay on board.
Next week, my lords, I have given a rejoinder today. Let them go through the rejoinder. Next week, your lordship may take up.
All right. Not till next week.
Extremely sorry.
Item 17.
I'm appealing for the opposite party number 10.
All right. Who's for the petitioner, sir? All right. None appears for the petitioner. Dismissal not discussion.
Item number 18.
And item number 17, I'm for the opposite part number 6.
All right.
Item 18.
Your Lordship, item number 18, I'm for the petitioner and the matter is infructuous.
All right. Dismissal.
I'm opposite party number 2.
All right. All right.
Item number 19.
19, I'm for the opposite party.
All right. None appears to the petitioner. Dismissed.
Item number 20.
Infructuous.
All right. None appears.
Opposite party.
None appears. Dismissal not discussion.
Item 21.
None appears. Dismissal not discussion.
Item number 22.
22, my lord, I may be permitted to file a fresh representation, my lord. Your lordship dispose of this writ petition.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation.
I'm appearing for the opposite.
Disposed of is withdrawn with liberty is paid.
Of like.
Item number 23.
23 may have paid, my lord. Here, my lord, I have paid for extension of the certain benefits under the Odisha resettlement and rehabilitation policy. Here, the petitioner is a displaced person. His land has been taken, my lord, in the year before when the 1977 policy was in force, my lord. Thereafter, my lord, certain benefits were withheld and not been extended. And thereafter, 2 policies were reformed, my lord. That is the 1994 policy came into force and thereafter 2006 policy. But I humbly pray that I may be granted liberty to approach the special land acquisition officer with all my
grievances.
grievances.
The petitioner seeks leave to withdraw the present petition with liberty to approach the special land acquisition officer with an appropriate representation. Disposed of as withdrawn with liberty is paid.
And time may be stipulated so that
if such representation is filed not later than 1st March 2023, after hearing the petitioners, it will be disposed of by reasoned order within a period of 3 months thereafter. All right.
Oh, bless me.
Item 24.
Yeah, I plead your lordship. My lord, the industrial lease, my lord, the lease deed, registered lease deed was executed. One lease deed was executed in the year 2003 till 74 now. So, lordship, and turn to
Yes, sir.
I will kindly turn to page 44, annexure 7, mine. That is a cancellation of allotment. And the grounds taken, my lord, 1, 2, 3, 4, 5, 6. That was not at all inquired into, my lord, and no personal hearing was conducted, my lord. And arbitrarily the order was passed. However, my lord, the appeal petition, your lordship, kindly see the appeal petition as per the order of the authority, my lord.
What was the allotment made to you for, sir?
Allotment for, my lord, manufacturing and selling of spices, my lord.
What did you do?
Young
with that land?
entrepreneur, my lord.
What did you do
He
with
has
the land?
paid the consideration money of valuable consideration money of 1,25,000, my lord, 10 decimals of land. And he has a postgraduate, he has completed his post-graduation, my lord. And the annexure 7, my lord, while it was not conducted, the inquiry was not conducted, and no hearing was personal, was only arbitrarily the order was passed. Annexure 7, my lord.
When was it allotted to you?
My lord, it was allotted in 2003 and by virtue of Annexure 1, my lord.
And
Annexure
the
1.
cancellation letter was 2014, 11 years later, correct?
18, page 18, my lord.
So 2003 allotment was made.
Yes. Yes, my lord.
2014 lease was cancelled.
It was cancelled.
So
Yes.
11 years.
11 years.
In 11 years, what did you do with that plot?
Yes, I have constructed, my lord. I have constructed the shop, and I have started my business, my lord. And this is the document, and the ground taken in the cancellation of
Who's
lease.
for IDCO? Who's for IDCO? You're for IDCO, sir. Somebody is appearing for IDCO or not?
Nobody is appearing. No counter is filed. I am having some document, my lord. I am paying the GST in 2020, 21, 22, registration certificate of the transport vehicle, my lord.
There was council appearing for IDCO, no?
And food license of the year 2022.
All right. The name Pranay Mohanty be indicated in the cause list for tomorrow. Stay on boards. Right.
My lord, tomorrow I may be.
Whatever, sir, we will see. Let it be.
Next week, my lord.
Let's see, sir. We won't pass an order adverse to you. Let him come first. You serve him a copy. You are aware of Mr. Pranay Mohanty, sir? You've heard his name?
PK Mohanty, senior advocate.
The day after tomorrow, I think.
First, you serve a copy on him, sir.
Yes, yes.
Item 25.
25 has become input.
All right. Dismissed as instructions.
Item 26.
26, not.
That's item 26. Our counter affidavit, the draft is ready, we'll have
2015 matters, sir.
I'm extremely sorry, but that's a counter is required, because it's a land in Bhubaneswar, prime property, which has been determined. So
stay on board.
Yes.
Item number 27.
Lordship will
stay on board. He says he's going to file a counter tomorrow. Tomorrow, is it, or today?
No, we'll may call it Monday. I'll file it through the week.
Anyway,
Monday.
Then call it next week. All right.
Item 27.
May I please, your lordship? Is the different kind of case, your lordship? The picture is the ex-serviceman, and then here they applied for the Joan lease, and on his application, my lord, an order is passed by the Tahsildar, my lord, allowing the petitioner, my lord. And but since then, the record had sent to the sub-collector for
Joan lease is over now, sir.
Joan lease is granted to the petitioner, my lord, for agricultural purposes, my lord. The petitioner is the ex-serviceman. Since 2003, the allotment made, my lord. The particulars given by the order, my lord, at page 18 of my
Today there is no Jawan lease policy.
There is, my lord.
There was. Now that's all over.
But the petitioner applied, my lord. Since then, the petitioner
What
has
to do, sir? Passage of time, everything doesn't
No,
wait for everyone.
Because why I am saying, your lordship, in the meantime, same salt plot, the Tahsildar has initiated a proclamation for another person. While he aware of the facts, my lord, the Tahsildar dropped that proceeding, my lord, the proclamation proceeding. Now the lease is already ordered, my lord, in favor of the petitioner. Now it is the
It can't be granted, sir. There is no. We can't issue mandamus for that.
Lordship, one thing I pray. Let them decide. If they don't have policy,
there is
then
no policy.
let them communicate to the petitioner.
Nothing. It's all public. It's all public knowledge. I am myself aware, sir, after coming to this court. You must be more aware than me. I am from some Delhi and Punjab and all that. I know that in Orissa there is no Jawan lease. Will you not know?
Jawan lease, your lordship. It is for the agricultural purposes. Then the policy, your lordship. It is their policy. I think my senior will and he can say because he's dealing with
instead we are paying one time
practice. He can
The policy of Jawan lease is no more in existence. Therefore, the prayers sought in the present petition cannot be granted. It will be open nevertheless to the petitioner to apply for benefits under the extant policy of the state government applying applicable to ex-service in accordance with law.
Lordship,
The petition is disposed of, the interim order is vacated. Right.
Another thing, lordship might pay.
Yes.
Let them communicate the petitioner regarding there is no such policy or whatever the
So
policy.
now you can ask your client to read this order. I have said that in the order itself.
Item 28.
May I please, Madam?
Yes.
This is a dispute between the BSNL Government of India Corporation.
Yes.
Way back in Annexure 1 series, 3 plots are given on alienation, the Government of India, Post and Telegraph Department, Annexure 1. Then 2000 Milord, BSNL was formed, and all the assets of the DOT, Department of Telecommunication, were transferred to the BSNL under Annexure 4. But under a mistaken impression that we have to apply for a fresh lease, the BSNL local authority of Koraput even application for lease. And they demanded so much of money, etc. Then we approached the government of Odisha, who under Annexure 18A at page 62 of my lord's brief. That is 15/13, I will get page 62 million. They have mentioned here, narrating the entire thing. Subsequently, the Ministry of Communication, Department of Telecommunication, Government of India, by Resolution 23/2001, have communicated the decision of central government that all assets and liabilities except assets which will be retained by the DOT, Department of Telecommunication, required for the unit and officers under the control of DOT of the Department of Telecom Service, DTS, and the Department of Telecom Service, and transfer the BSNL with effect of 1/10/2010. On the basis of the said decision, Government of India, the CGMT BSNL, Odisha Telecom Circle, has requested the department to issue instruction to the district collector to effect appropriate changes in the revenue records with respect to all the properties which originally stood in the name of the DOT to be changed in the name of BSNL. In this connection, he has also enclosed a schedule of properties to be transferred to the name of BSNL within Odisha Circle with enclosed. As we have seen from the schedule, properties furnished by the CGM, Chief General Manager BSNL, while some of the properties are held by the DOT on outright purchase basis, some are on leasehold. As regards the land owned by DOT on outright purchase basis, BSNL being the successor of DOT, in respect of these lands, may file application before the appropriate revenue authority for mutation of these lands in name of the accordance with the provisions of the Orissa Mutation Manual. Basing on the decision of the Government of India for transfer of assets, accordingly, the instruction may be issued to the concerned Tahsildars to do the needful respect to the application. As regards the leasehold property, DOT government has consultation with the law department have been pleased to decide that the following procedure is followed. So these are declared the outright purchase basis on Annexure 1 series. So these, after the instruction, I approached the then collector in next Annexure 19. He files a letter. You file the documents, Department of Telecommunication. I submitted Annexure 20. I submitted all the details, outright purchase document to him. Then, in spite of that, he is going on demanding about 6 crores, Annex 23, that you pay this much amount, including premium, etc., everything. And Annex 24, I had also asked that giving all the details, this is not payable. Then Annex 25, my lord, I said that I withdraw my application for lease, 25Cs, 3 applications. In spite of that, he is going for certificate proceeding. I have filed a rejoinder. Similar, I have approached the Revenue Divisional Commissioner of Ganjam, South Division, who has also passed an order, Annex 28, to my rejoinder. Yes, I have filed the last dot, I filed page 28, Annex 28, page 4 of the rejoinder. He has also said the same thing. In reply to the apostle letter, status report has been furnished by the district office, which speaks that as in 4 lease cases have record bearing such were initiated and lease were sanctioned by such, and the sanction order has been given as the BSNL authority did not execute the lease deed within the specific period laid down by the sanction order, basing on the report of the furnished in the letter of reference. Chief General Manager BSNL has moved by letter no. 12/3/2015 to take steps for clearance of the outstanding dues. Then, Chief General Manager BSNL Bhubaneswar, in a letter number such and such dated 25/6/2015, has furnished a detailed report in the regard with copy sent to you in the next memo. General Manager Telecom Koraput has also furnished detailed report, filed office letter no. 12/5/15, on careful analysis of the said report furnished by BSNL authority. The following facts come to light. 1. Transfer deed was executed between Collector Koraput and Divisional Engineer Telecom Bhuvanaspur on 27/11/2020.
Stand of the government. How can they be asked to pay? You yourself have said they should not be asked.
Millers might see the circular, the 2013 circular.
In fact, that's all been applied. Now look at his rejoinder.
Yes,
they've referred to that circular. The RDC is himself saying now in 2015.
Yes, Millers.
That dropped the whole thing.
In the last, he says, in circumstances, I'm directed to request you that the matter may please be examined in the proper perspective.
Before that, he says nothing. It's not justified at all. All these circulars he's referring to.
Please, Millers. The counter that we had filed in 2015, Millers, there, Millers, the circular says, if my lords may turn to page 63, my lords, for a moment. Para 6, my lords, if I may read. As regards the leasehold lands held by DOT, government in consultation with Law Department has been pleased to decide that lands may be transferred in favor of BSNL subject to the following conditions. No further premium shall be paid by BSNL since DOT has already paid the premium at the time of alienation. Unless a categorical stand is that no premium.
Then you have to withdraw all these notices, then we close the petition then. Just withdraw the impure notices and we close the petition.
No, in 2015, the counter affidavit that we had filed, there, we have taken the categorical stand that no premium had been paid by the Department of Postal and Telegraphs, which was the predecessor, and therefore they have to pay the premium. That is, my lords may see page 8 of my counter, para 16, my lords. It is submitted that since the petitioner has not paid any premium against the demanded amount for the lands under his illegal and unauthorized possession since 1985, they are required to pay the premium along with ground rent, cess, so-and-so. It is further submitted that the circular number so-and-so dated 15th and 2013 has been misrepresented. The contents of the said circular clearly reveals in paragraph.
Come to your, this rejoinder, have given him a copy?
Yes, Millers.
Come turn to annexure 28 now. What is the date of this annexure you read?
26/2015.
This is from who? This is from the RDC.
RDC.
Who's your man?
Yes.
Now come to the second page of that.
Yes,
bottom paragraph.
Please.
Read it.
In pursuance to Rule 282(1) of...
No, after that.
The Chief General Manager BSNL Bhubaneswar also specifically mentioned that their organization is not liable to pay any amount towards premium. Their claim for non-payment of premium seems to be justified in view of the instruction communicated in letter number so and so of Government of Revenue Department and letter number this dated 15/10/2013 of Government.
This is the RDC himself saying, yes, the claim seems justified. So where's the question of their being asked to pay premium now? Yes. You can't be saying blowing hot and cold like this. You better be clear what you're trying to say. This is RDC saying this to the collector.
If my lords gives me 2 days time, I'll get specific reply.
You better take instruction.
Grateful.
All right.
Item 29.
Memo taken on the board.
Item number 30.
29.
Yes, withdrawn.
30, my lord. 11th January, State Council has taken time to file the counter, my lord. Counter has not yet filed, my lord.
Rehabilitation assistance scheme. This is now pending the Supreme Court, sir.
It is all pending in Supreme Court in that excise matter also, Your Lordship.
Correct, correct.
Mr. Kuntia is there.
Since the matter concerning applicability of the rehabilitation assistance scheme is pending the Supreme Court before a larger bench, the petition is adjourned sine die with liberty to the parties to mention it for listing after the judgment of the Supreme Court. Yeah, 5 more minutes. Thanks.
Item 31.
This cannot be adjudicated here, my lord. My lord, the brief fact is that a section 25 notification for eviction was issued. My lord. Then we approached the trust board. Trust board has passed the resolution, my lord. I have filed it by the way of counter. Then a section 19 proceeding has also been initiated. No order has been passed in section 25 nor in section 19. I only now they have raised that some interveners have joined there, so we have not joined them as parties. This that, but that would not be necessary if your lordship directs that the section 19 application may be first disposed of, and if they find that it is rejected, then they will take the course to section 25 within a stipulated period.
All right.
And I am for the opposite party number 2, my friend.
All right. It appears that the proceedings under section 19 of the Orissa Hindu Religious Endowment Act 1951 is still pending before the Commissioner Endowments. Mr. Ashok Mohanty, learned senior counsel for the petitioner accordingly.
Assistant Commissioner. It is pending before the Assistant Commissioner.
Assistant Commissioner. Okay.
No, my lord, before the Commissioner.
Before the Commissioner, Your Honor.
Sorry.
Mr. Ashok Mohanty,
19 can
senior
only be
counsel, the petitioner accordingly submits that a time-bound direction may be issued for disposal of those proceedings, and depending on the outcome of such proceedings, further remedies can be sought by the agreed parties in accordance with law. A direction is issued that the pending proceedings before the Commissioner under section 19 of the OHRE Act be proceeded with and concluded within a period of 6 months from today, after hearing all the parties involved. Full stop. It will be open to the agreed parties thereafter to seek appropriate remedies in accordance with law. The court clarifies it has not expressed any view in the matter. Status quo as to the as of today shall be maintained till the disposal of the matter by the Commissioner of Endowments.
May I submit my lord? There is a proceeding under section 25 pending before the self-land way back in 2010 as per the direction of this honorable court. But annexure A/2, I have filed a counter affidavit on behalf of the opposite party number 2.
That will be decided. That no final order has been passed in
and
section
the
25.
of the land is water bodies.
Now, section 25
That is
Has
pending since
not yet been
2008 after
decided.
the direction of this court, and that has not been vacated by this honorable.
No, both have to be heard by the same commissioner.
Ah,
All right. You said the proceedings both under section 19 as well as section 25. All right.
I'm appearing for Kotak Development Authority, my name may be recorded.
All right. Yes, yes, she's submitted.
Item 32.
None appeals for the petition. This one.
32.
No, 32, I'm for respondent 2 and 3.
All right. All right.
Obliged for that.
Item number
Contempt also dismissed.
Item 33.
But item 33, let's say, this matter, the similar matters are going and hearing in the court number 1. Lordship has already directed to list this matter. In 16, it was listed, some of the matter. Lordship already directed to. Well, now it is posted on 10th, Lord. All the batch of matter has been posted to 10th, Lord.
All right. Same matter. Right. Before a bench of justice.
Next connected matter also same.
All right. All right.